Your Lordship complied, Your Lordship, in filing the affidavit.
My Lord, sir, mention karna. My Lord, sir.
Why it was not compliant? Now it is compliant already. It is keep returning the goods. I have returned the stolen goods. Therefore, don't take action against it.
Your Lordship.
Milords, on that occasion also, Milords told me that whether it is a pressure or intentional. In fact, it is a tremendous pressure, Milord. Yeah, Tirumala Nai.
Your Lordship. Your Lordship, there was.
Order to do, no? Potential.
We have this suspension. For 3 months working. I don't take this. Where is he?
Your Lordship, there was no specific order for his personal appearance. No. Yes, Your Lordship.
To comply the order, if not.
If not, then. Yes, Your Lordship.
On what time putting those Saturday, Sunday was holiday. Too much care and concern, Your Lordship's order that has been taken. Henceforth, it will not be repeated.
Henceforth, Your Lordship will.
Something has to be done to it. Otherwise, the rest of the IAS officers start behaving like Babus. Babuism is contrary to constitutional needs. We are not governed by the Babus. Babus are servants of people.
Exactly.
These Babu, from which state to which state he is from? So,
Sir, order.
Direct the central government to return to some other Kashmir.
All this time be excused in henceforth it will be then.
That sure may face to do the hits. Tomorrow they will not believe. They see me, they will say this is the Indian Constitution. They read the thing to the Babus who violated law. What they should say?
They have been sufficiently cautioned, Lordship, not to take the court for granted, Lordship.
14 cases.
Other cases are there also. We do consider.
14 is a very minuscule of the cases that are pending against them, Lordship. Yes, Lordship.
No, what he thinks, what your latest people are thinking. Or let them sit in the defendants against our order so that they can reverse our orders if appealed. They are servants of the people.
Yes, Your Lordship.
Servant should be. Also, if you are servant,
they belong to the civil service, Your Lordship, which means service to the
servants of the people.
This kind.
Your IAS officers should know they are servants of the people. How a servant should be? Servants should serve the masters. Judges are also servants. We should serve people. This kind of IAS officer, he will spread the disease of disobeying the court orders to rest of the IAS officers. Therefore, if one is put in prison, things will be all right here off. That appears to be the thing. Now he has complied his norms. It is the keep returning the goods. By returning the goods, he does not become an honest gentleman. He should be punished for contempt. That way, he should be punished for contempt. Tell how much cost should be. How he should be directly in prison.
Henceforth, Your Lordship, any disobedience, Your Lordship, henceforth.
It is like again keep saying, so I have written them. No, that kind of proposition I.
On the request of the law officers, Your Lordship. Henceforth, Your Lordship may.
God is to honor and the contempt of the size and the pleasure of the pleasure of the law. If he forgets, then he should punish. At least 1 month suspension, something. I don't have to subscribe.
Millard, this is a case, it is an exemplary case, Millard. It was on Friday, and my lord, a specific order to 10:30 should be complied, or else this will. My lord, let
this today he be excused if in further disobedience of this order, Your Lordship, Even we will not stand in the way, Your Lordship.
We have no gentleman has to offer an apology to the High Court. This is a constitutional court. There is apology.
Lordship, even an affidavit, Your Lordship, but not he. Yes.
By delayed compliance, contempt not pursued. That's a standard book on law of contempt. Probably a year later. This means delayed compliance will not work the guilt of contempt.
Last chance, my lord.
As a last.
And henceforth, this because series of matters are there, and this is an example, my lord.
As an example, they also have come to know. Yes, Your Lordship. This is a regularization.
No, Lordship. Only letter is gives. Now I have learned AGS submitted this one, and only letter is there.
Thank you,
Escape from the order, I want to see.
Escape from
the clutches of contempt court if it does something. That I will not. What is that order?
Page 6.
Where is that order now?
No, last order. Last order, my lords, on 8/5/2026, in case of Deepak Kumar Behra. Copy the
They are very regular.
Yes.
Yes.
Regular. Now we paid 16,600.
Yeah.
He's a Jew. Therefore, he does not want to kill. He is IAS, and this person is a Jew. Therefore, this can be related with IAS powers. That's a question. We differ from 1 to 2020.
Yes, Lordship.
They have complained.
Letter of joining, yes.
Do you want this court to take action, or you want to show mercy to the IAS power? You can.
This is to your Lordship. I can.
Don't leave it. Don't leave it. Whether like you wants to show mercy to the IAS officer, or he wants to take action against the IAS officer. Whether my mind is here,
No, Lordship.
because I want to put this IAS officer at the mercy of the Jew. That's the way. If the IAS officer should be at the mercy of the Jew, doing only in non-compliance of order. Otherwise, they won't want that will be unconstitutional. Ask your client whether that Jew is ready to argue this IAS officer. Ask your client.
Yes. Fixed to any other. Yes, yes, Lordship.
Ask him whether he wants to fight with that IAS officer or he wants action to be taken against the IAS officer.
Yes, Lordship.
From here. From here.
Pass over then I.
No, why pass over?
Yes, Lordship. Then I am asking her.
Where are you going? Ask him. What he is asking, whether you wants to argue the IAS officer or he wants to take action against the IAS officer. Ask your asking you native language.
हाँ नमस्कार आज तुम केसटा अच्छी है लगी से आज जो एफिडेविट गोटे फाइल कर लिखिं जे तुमको 1/2/2020 रु परमानेंट पोस्ट करते डेट ऑफ जॉइनिंग रु बाकी ऑनरेबल कोर्ट पचार कि मैं तुमको एक्सक्यूज करने चाहूँ ना एनी पेंशन आईएएस ऑफिसर ऑनरेबल कोर्ट पचारे चाहते क्षमा कर ना किसी पनिशमेंट हवा दरकार ನಾನು ଅର୍ଡର ଦେଇଛନ୍ତି ପଇସାଟା 7 ଦିନ ଭିତରେ ଦେବେ ବୋଲି ଲେଖିଛନ୍ତି। ହଁ ସେ କହୁଛନ୍ତି ଯଦି ମତେ ପଇସା 7 ଦିନ ଭିତରେ ଦେଇଦେଲେ ମୁଁ କ୍ଷମା କରିବି। He's saying that if within 7 days they are going to pay my arrear salary and fixation of the that is the, in order it is there, then I will excuse it.
You will excuse me, right? This complaint, this complaint is also if there are enters in complainants WBC number 2869 of the after service of duties, the petitioners navigated appearance to the WBGA. Whether an apology is the proposal of or we should expect something from
He'll apologize. He will offer up.
My lord, in a written form also we can file this affidavit. No,
Right.
it is not intentional.
Is it not?
This court, when order dated 8/5/2026, had narrated the acts of non-compliance with the wrote in the interpretation as customs. Now, in the threat of violation detention, the contestants have filed a compliance affidavit dated 11/5/2026, accompanied by inter alia and order number 6347 8/5/2026. Whereby compliance in reporting. Compliance is the first one. The contender happens to be the person, the gentleman holding the post of peon. And delayed compliance not amounting to purging the guilt, has a very graciously forgiven the contemner IAS officers, contemner IAS, contemner Tribunal IAS, who happens to be commissioner cum secretary. First one, since the contemner himself is forgiving to the IAS officer, this court accordance with the same idea, and the place sets the encomium on the place shown by the peon to the IAS officer. First, next paragraph. Though it sounds strange, that no written apology is tendered. Now, the letter which is Madam so and so and Mr. Mohanty very passionately submit that the official right to the contender offers apology, unconditional apology. Is it unconditional?
Yes,
Unconditional apology. And therefore, he should be excused. They also assured on behalf of the contenders that hereafter such a non-compliance would not happen in respect of court orders. it affects all the of the municipal. Yes, correct. This court very reluctantly accept the apology. And this is on record. The excuse the record the complaint for giving the IAS purpose and therefore drops the proceedings with a warning that hereafter non-compliance would not be tolerated. Proceedings are according to law. Next, the order should be sent to the Chief Secretary of the Orissa or be certificated amongst the all civil servants, including position, so that the rule of law is stored in this state. Next. Content 6.1.
Your Lordship, in the course of the day, we are filing the compliance affidavit, the orders to that effect, Your Lordship.
It is not been complied with.
Next one, sir.
I have to say, my lord, let him continue. And if you are not giving a copy to, how can I submit to the court? You are giving a copy to. How can I submit?
What has he done? Now, what is this? What has been done now? Complaints of possibly by Kahu versus so and so has been allowed. RCP is allowed.
Yes, Your Lordship.
No, just look into.
Yes, I have seen.
And Your Lordship,
Along with my note.
he's also
If you will
written
allow me to speak,
character elementary education. He's also written that accordingly, revised pension papers in duplicate in respect of Srimati Sukanti Sahu are hereby submitted to your office for taking necessary action at your end and onward transmission to the control of accounts Orissa Bhubaneswar for sanction and authorization of revised pension, gratuity and other retired benefits by taking into account the benefit of third RACP restored in compliance with the Honorable High Court order and government instructions issued by letter number such and such 4/5/2026 of School and Mass Education Department. You are therefore requested to kindly process the matter and transmit the revised pension papers to the control of accounts Orissa for early sanction or revised pension benefits in favor of Sukanti sir.
Kindly see my lord's order. The judgment my lord have delivered on 3/9.
OP numbers 1, 4 and 5 to sanction and pay to the petitioner regular pension and all the terminal benefits with interest at 7% per annum with effect from 1 year after retirement. Where have you stated give that money with interest?
Thereafter.
Terms of court order.
All
Kindly see my 10/4 order. Again, another order of my lord. When
Another
dropping the
order.
content. 10/4/26. There also for non-compliance.
10/4.
10/4/26.
We are dropping the proceedings.
Yes.
Would pay to the complainants rupees 1 lakh in a lump sum and rupees 1,000 per day of delay in compliance.
It was dropped. Till then, nothing was paid. I have filed this IA for restoration of the contempt, revival of the contempt petition.
Now, what about rupees 1 lakh?
All these will be paid, Your Lordship. His third
Yes, it will paid.
together it will be paid, Your Lordship.
When it will be paid?
Your Lordship may keep it to Friday. We will pay in the meantime.
Friday.
By
Why Friday?
or
Today.
Today, Your Lordship.
Today around
Tomorrow at 10:30, Your Lordship, we will file the compliance affidavit, Your Lordship, with all the payments.
today. Otherwise, I will not leave them. Otherwise, I will not leave this office.
Tomorrow 10:30. Today we will make the compliance before the court.
Pass
Before the
call it 2 p.m.
3:30, Your Lordship. 3:30.
All right. 3:45.
Oblige, Your Lordship.
Yes.
Item 3, Your Lordship. Item 3, Your Lordship, may give me time till Friday because, Your Lordship, it is depend. The finance department has to return the amount that was deducted. So they have written, they are processing it, Your Lordship, or it may keep it to tomorrow, Your Lordship. I will.
When the order was?
On Friday, Your Lordship. Saturday was the.
11/12/2025.
Yes, Your Lordship.
Even after order deduction has been made.
2 deductions, Your Lordship. That they will return, Your Lordship.
It is like saying a thief saying, I have not taken 2 gold coins from the treasury.
No,
only 1 coin.
Your Lordship, I have already inside the officials, Your Lordship. They are, because the finance department, they have written to the finance department to, they have stopped the deduction, Your Lordship, on 6/3/2026, and the excess that they have deducted, they are going to return, Your Lordship. That was my instruction, Your Lordship. I keep it to tomorrow at 10:30. They would have processed it by today.
10:30 tomorrow.
Obliged, Your Lordship.
Yes. For reporting compliance, dwelling which arrest and detention may be ordered against the errant or issue. What will be? You are not giving opportunity to this court to imprison the violators of court orders.
After today, Your
You
Lordship.
should give opportunity to
Today is the last chance for all the law officers, Your Lordship. Your Lordship, it is compliant, Your Lordship.
Comply.
Yes, Your Lordship.
Give it copy to the friend and get his signature that he has received. Hey, give that back. You should give copy. They should endorse that we have received the copy. Then you should pass on to the court. Not taking like this is not a tea shop.
Yes, Your Lordship.
Take his acknowledgement. And hereafter, at least in my court, that will be the procedure. Giving copy in advance, then they should be given time to read.
Yes,
Then
Your Lordship.
these things, not like this.
Today, Monday morning, Your Lordship, they've all come. We couldn't even e-file it, Your Lordship. Shortage of paucity of time, Your Lordship.
Complied with.
Yes, Your Lordship.
What is the kind of compliance? Positive compliance or negative compliance?
Positive, Your Lordship. We had.
Positive.
Yes. He has been regularized from his initial date of service, Your Lordship.
With effect from 5/2/2020.
Yes, yes.
Brother, he is regularized.
Yes.
Ask your client whether he wants to who is the same officer.
Same officer.
Same officer.
Same.
Ask your client, another client or same client, different client.
Another client.
Ask him whether he wants to forgive. If he forgives, I can forgive. Otherwise, we have no discretion to forgive an officer when the citizen does not want. Citizen should not be at the mercy of the babus. Babus should be at the mercy of the citizens. Ask your client whether he wants to forgive the IAS officer.
हेलो हेलो प्रणाम आज आप केसटा अच्छे कोर्ट रे से माने कंप्लेंट्स एफिडेविट देइचंती से माने लिखिचंती जे 22/2020 रु आपनकर रेगुलराइज करिसंती एवं बाकी फाइनेंस पार्टटा देई नाती सेटा फाइनेंस पार्टटा 7 डेज 7 दिन भीतर देबा को देई देबे कहउचंती आपण जो कमिश्नर अछंती तांको आपण एक्सक्यूज कर देबा को चाहउचंती ना नहीं कोर्ट पचारचंती.
Tell him in Orissa, don't say excuse. He may not understand that word. Tell lower level employee. Tell him in क्षमा करता है क्या पूछो.
अनवल कोर्ट पचारिया को चाहउचंती आपण तां क्षमा करिया को चाहउचंती ना नहीं. से क्वेश्चन यदि मार रेगुलर हे गेले एवं 7 दिन भीतर पैसा इफ ही गेट द अमाउंट विदिन 7 डेज यू विल एक्सक्यूज.
He will excuse. Yes. What is he? Pune?
Yeah, Your
The
Lordship.
Pune will excuse the IAS officer now graciously.
No, he's clerk.
He's clerk, Your Lordship. He's a clerk.
No problem.
Yes.
Only a higher level. Within 7 days, you are making the payments. And if you do not pay, then
Your Lordship may call upon the officials personally to appear before the court, Your Lordship, and explain that.
now I will drop with the conditional dropping. 1 lakh rupees from the pocket. From his pocket.
Today is the last day, Your Lordship, of even we law officers requesting on behalf of the government, Lordship. Today, and with caution, Your Lordship, I pass the order. So from next day onwards, Your Lordship, if next case on Your Lordship.
Money is the panacea. Money, not others' money.
Your Lordship, because there are number of cases lying with the Secretary, Your Lordship. If they fall to there,
if he does not want to come, not be able to do the job, let him quit. Some other officer will come there. It's a good suggestion.
Yes, Your Lordship, nobody is indispensable, Lordship.
Nobody is indispensable. You're right. Take note. The complaint alleges violation of the final order dated 21/8/2025, whereby complainant's WPC number 17335 of 2024 was disposed of granting relief. First, as would happen in this state, unless contempt proceedings are taken up, government and its functionaries do not comply with the court orders. And compliance is an exception, non-compliance being the rule. First of all, that will not augur well to the rule of law, which is held to be one of the basic features of the Constitution of India, White Case 1 of law. First of all. Next one. Be the above as it is, This court any interim order was made. Be the above as it is. Now the contemners have passed 2 orders. That is order number 11976 SME dated 8/5/2026 and order number 6343 dated 8/5/2026, complying with the writ. First off, there is an enormous delay in compliance. First off. Therefore, the complainant, who is in the cadre of clerk, was asked as to whether he would forgive the contemner IAS officer for the act of non-compliance of the court order. And he graciously has forgiven the contemner, subject to the rider that all financial benefits accruing from the order should reach his hand within 7 days. First of all, with this proposal, learned AGA defending the contemner is agreeable. Are you agreeable? Perfect. Agreeable. First of all, in view of that, since the citizen himself has excused the IAS officer who has violated the court order and now has complied with the court orders with enormous delay, this court also forgives him with the warning that is the event, the financial benefits that have been undertaken to be paid to the contemner do not reach his hand, that would be an act of aggravated contempt for which the contemner can take separate proceedings.
I beg your apology, Your Lordship. 7 working days, Your Lordship.
Within 7 working days.
Obliged, Your Lordship.
With the above observations, proceedings are dropped with liberty as indicated above. Suppose if they do not pay within 7 days, move another contempt. That will come before me only. Okay. You are trying to become richer.
See, next one also Niharika Ponda. The same IS.
Sub-items are same, Your Lordship.
Same order.
Yes,
Both are same.
both we have also.
Niharika and Ramakrishna Patra.
Same order.
Your Lordship, may I pray something, Lordship? That item 1, this rider of 7 days should be given. Item 1,
7 working days.
amount 2.
Item 1.
Yes.
In item number 1, 7 days for paying the financial districts. All right. And that sentence to be where is this one? Our researcher, where is it from? All right. Then for admission, what is that? Huh? This is what? All right.
He is a specialist for this special matter.
Specialist. Tomorrow again specialist. So much time is wasted. So many people waiting for their cases. It hurts me. But inevitable. What should I do?
You obliged, Your Lordship, for your honesty.
This application is challenging the order passed by the learned Cat Miller in 18/12/2025, wherein, as against the concurrent findings of the appellate authority, revisional authority, so that the disciplinary authority, they are directed for reinstatement to all wages law. That is the substance.
They have
Now-
followed Gunashekaran.
Yes, Gunashekaran, yes, ma'am. That also I relied upon. He has traveled beyond his jurisdiction to scrutinize the evidence, Lord. That is right. And also, while scrutinizing the evidence, he has omitted the important things and relied upon the thing which has been in support of the employee. That is one.
Selective, very selective they are.
Yes, yes.
To take notice,
Minus.
issue emergent notice. Matter lies in a narrow compass. Call after service.
I filed a IA. I filed a IA for stay of the in order.
We'll consider it after their entry. IA should be considered after the entry of the office. I don't know, problem to say it was Yes, sir.
Pardon, my dear. Item 2, I am appearing on information DS this minute. Argument.
Any urgency?
The urgency, if my learned friend is playing first letter.
No, what's the urgency?
Urgency, my lord, the petitioner is a urban cooperative bank. Here, the petitioner has challenged the order of ARCS, Assistant Register Cooperative Society, without his jurisdiction. ARCS has passed the order to return the loan document to the loanee, whereas loanee has not cleared the loan dues. And in the meantime, matter has pending before the cooperative tribunal. And Register Cooperative has clearly passed the order that execution is not maintainable. But ARCS overriding the decision of the Register Cooperative Society has passed an administrative order to return the loan document.
Till next date, you maintain, don't return the document.
Yes, Your Lordship.
You will have it after vacation.
What's the kind of ticket?
No, we cannot do that way. Once you seek adjournment, you should leave the discretion to the judges to fix the date, because many other matters.
And in the meantime, petition has also paid the amount to the entire amount to the my lord auction purchaser.
Kindly take a 2 more minutes.
Issue emergent notice. You are the curator.
Yes.
Yes.
And I have also already served the copy
Yeah.
since 25/3/2026.
Learned counsel appearing for the curator seeks a short accommodation. First term. Request having been accorded, we direct the parties not to precipitate the matter under the impugned order till next date of hearing. Call immediately after occasion. Yes. In the meanwhile, objections may be filed to the IA. Okay.
My lords, this case, my lord, I challenge the order of the Lord Central Administrative Tribunal, my lord. The matter is that for allowing the petitioner to pay the third MSCP, my lord. In this case, my lord, that is like that. The applicant initially appointment as the assistant station master. Subsequently, they have applied for the post of training, apprentice training under the traffic, my lord.
You are for the petitioner or?
I am the petitioner. The opposite party is applicant before the OAF, my lord.
You are Union of India.
Yes, my lord.
But the identical matter was before the apex court.
My lord, that is a case of Ashok Kumar Barik that has
correct.
yes, my lord.
That is false.
So that case completely different from my case because because my lord, in this case, my lord, they have claimed that he is entitled to get in initial state assistant station master. So subsequently direct recruitment to the post of traffic inspector, my lord, promoted traffic inspector. We are saying that you are entitled to get when you joined as a traffic inspector, man.
What happens to the service which he has already rendered in another post?
That is not considered by the.
Well, we will say that.
My lord.
Now, where is the case file? No case file. Even according to you,
My lord.
he was shifted from X post to Y post.
My lord.
The service rendered in X post, can you discount for the purpose of granting these benefits?
When in this case, my lord, you are so right. In this case, that has not been given by the tribunal. Only given by the when he joined as a traffic inspector to that effect, including the training period. In view of the RB circular, in the training period, he has not entitled to get the benefit of the third MSCP.
Where is that circular?
Yes, ma'am. A circular giving that.
Show that. But training period is post-appointment.
That is post.
Yes, we in
An employee only.
Let's see, kindly see page 69. Let's see.
69.
Yes, ma'am. That is annexure A by 8 filed by the.
How various tribunals in the country have constituted this circular?
That is.
That research you will never do.
Just I may be permitted to read that one. Only paragraph. You got it, Your Worship?
Para 4.
Para 4, Your Worship. As per RB number 10 by 2009.9, post continuous regular service in another government or department in a post carrying same grade pay prior to regular appointment, a new department without a break shall also be counted towards qualifying regular service for the post of MSCP only. In your case, you have undergone 2 years training as traffic apprentice, which is not regular service, though you have applied through proper channel for traffic apprentice. It was under RRB previous open market advertisement.
No, this is the Principal Chief Personnel Officer's letter.
Yes, ma'am.
This is a letter addressed to Mr. P.K. Mishra,
Chief Traffic in my lord.
Chief Traffic Inspector.
Yes.
Where is the policy statement?
Yes, that is, Your Lordship. That is, Your Lordship, running page 73.
73.
Modified Assured Career Progress Scheme.
Which paragraph?
9, Your Lordship, page 75.
25.
That was 9, paragraph 9, Your Lordship. The regular service, ma'am.
Also, service rendered on ad hoc or contract basis before regular appointment shall not be. However, past continuous regular service in another government, where is that? So how it's para 9 supports the employee, not you.
Then, my lord, I just it shall also be counted person.
If it is ad hoc, then not countable. Regular, it has to be.
That is it. Yes.
Apex Court in one Rajasthan forest matter,
Ma'am.
that was in 90s, said there is difference between training post-appointment, training as a precondition for appointment.
Yes.
If it is post-appointment training,
Ma'am.
then it is a service.
Treated as a regular service.
That's how Apex Court has said in Rajasthan on forest matter.
Here it was made very clear, pre-appointment.
Very clear. It's a regular appointment only.
That is the in case of cited by the
Indian government is invoking the jurisdiction of this court for assailing the Cuttack Central Administrative Tribunal's order dated 20 February 2025, whereby OP's OA number 318 of 2021 having been favored, the following benefit has been conferred on operating person. Next slide. Having heard a learned counsel for the petitioners and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned tribunal, that the post-appointment training has to be
considered as service only in the absence of any rule to the contrary having been demonstrated. First, that happens to be the jugular vein of this case, and nothing beyond that. First, it has long been settled by the apex court in a catena of decisions that there is a difference between training as a precondition for appointment and training post-appointment. First, in the later, even the training period shall be reckoned as regular service period. First, that is how the impugned order of the tribunal has been structured. First, next one. The second contention of learned senior panel counsel that in view of go to page para 76 or 77, which page you said?
Page minor, I'm in 75.
70.
And
Clause 9.
I am in contention of learned panel counsel that in view of the policy guidelines promulgated with the title, all capitals, go to 73, Modified Assured Career Progression Scheme, MACPS. Come on. The OP was not entitled to the relief which the tribunal has granted. Is bit difficult to countenance. First, paragraph 9 of the policy statement reads as a after reproducing, one more line you have to add. Paragraph 9 excludes only irregular service or ad hoc service or service on contract basis. First, that is not the case of the OP at all. First, next, in the above circumstances, this writ petition is liable to be dismissed and accordingly it is, in limine. First, registry to send a copy of this order to the OP by speed post immediately for his file. The OP's, the petitioner shall comply with the order, impugned order of the tribunal within an outer limit of 8 weeks. Yes.
WBC Government Fact 94 of 2006.
In this case, you will also kindly take note of my appearance only. The case that you are judgment.
Possible.
You want password?
Yeah, item 3, my lord.
In item 3, you are
Three. You are for the employee.
I was, yes.
Where have you argued?
Your lordship has already taken care of the case.
No, therefore, where have you argued?
We have said it.
No, you can go to the right from the yes.
Possible.
Password.
Item 4.
Yes.
I have instructed to appear for the sole OP man. May my lord may supply a copy can taken tomorrow or day tomorrow. And moreover, this matter is covered to my lord's judgment.
Covered by judgment.
Yes, my lord. Because the authority was
We'll have it
part of
tomorrow. Yes, sir. We'll have it tomorrow. Day after tomorrow.
my lord.
Tomorrow the contempt petition is posting to
Posted to on which day?
14th or 15th.
14th or 15th. Tomorrow is what?
Possible, madam. Just one possible.
Your senior wants to come and argue.
Madam.
Your senior wants to come and argue, or you only will argue?
My lord.
Possible. We'll have it tomorrow. Tomorrow. Call this matter tomorrow.
A copy, my lord.
Give copy.
Right.
And you give the copy of the judgment which you say is covered.
Just now I'm
Yes, next.
WBC Government 880/126.
Petitioner had a very low regard for his smooth functioning of his gas agency.
Huh? Gas agency.
Gas agency.
Business loan.
Lordship.
Huh.
Milord in
How much it is?
annexure 3, Milord, there was
Already you answer our question. How much money?
many more than 70
54
lakhs. Now, Milord, at settlement at annexure 3, 60 lakhs it was settled.
60 lakhs.
60 lakhs. But
You have
I-
settled.
No, I could only pay 35 lakhs up to 31st of March. That was the deadline. Now, another 35 lakhs I could not pay. That only I pay, Milord, let the notice go to both the opposite parties, let them apply.
Well, you have to
I had sought for some time before them.
So they have taken the symbolic possession.
They will take actual possession also.
Only I pray for some time, that is
Not a housing loan. In housing loan, see, emotions are attached, children are born there, and the houses are constructed with the blood and toil, the sweat and blood of the owners. There we can be a little merciful. Not in for a business people.
only residential. I will pay, my lord, only residential house. Within 2 months, I could able to pay 35.
Entire money.
No, another 35 lakhs I pay only 3 months. That is the only.
Issue emergent notice.
First.
First off, in addition to taking usual steps, petitioner borrower shall take a court notice by hand and serve it on the OPs. OP number 2. First off, notice on behalf of OP number 1, collector cum district magistrate is accepted by Mr. G on our request. Yes. Post immediately after service. One sentence, sir, 1 second. One sentence you have to write. The counsel for the petitioner on instruction of his client submits that petitioner is ready and willing to settle the entire outstanding if a reasonable time is granted. First, with that impression, notice is ordered to the other side. Okay.
Lordship, I am requesting us to pass over.
You start arguing. If there is difficulty, we'll give time to you. You start arguing. What is this matter? Is it RSA, RFA, or contempt petition?
Petition.
Bench petition. Filed under which section of CPC?
6.
Huh?
226. Article 226.
Article 226 of CPC. Constitution. Then what are the facts now?
The Lordship, this present petition has been filed by the petitioner challenging the arbitrary action and illegal action of the bank. There are 4 points that we have taken into consideration, 4 actions. First is challenging an e-auction without any clear title and deliverable possession. Second is suppression material defects.
You are buyer.
Auction buyer.
No.
You are borrower.
No, I'm not borrower. I am bona fide auction purchase.
That's what.
I'm a third party.
Generally, the word purchaser does not appear in Transfer of Property Act. It applies in the Sale of Goods Act. Purchaser word refers to chattel. Buying refers to immobile property. But fine. Anyway, no problem. Since you are an youngster, I said that.
A third is
No, let him take on the heard learned counsel, Miss or Mrs. what? Srimati.
Mishra.
Srimati. So and so.
Pardon me,
You
Lordship.
argued very well.
Yes.
First up, issue emergent notice. We are issuing notice. You accept notice.
Yes, Your Lordship.
Issue emergent notice. Learned panel counsel Sri. So and so accepts notice for OP numbers 1 and 2. 1 and 2.
Yes, Your Lordship. For the UCO Bank.
Union Bank also.
No, Your Lordship. For
UCO
the
Bank.
for the UCO Bank. I'm appearing on behalf of the Standing Council of the UCO Bank.
Emergent notice 2, 3 and 4. Post immediately after service. Yes. Why you needed password? You argued so well. Yes.
Item 7, new graphic 692 of 2025.
Yes.
The only point involved is whether the resolution shall be treated as a proposed resolution for a no confidence motion against the chairperson of a municipality.
24.
Section 54 in the
Of corresponding section.
The corresponding provision. Your Lordship, in the full bench, categorical and when there is a statutory requirement of the proposed resolution, it must accompany with the proposed resolution.
Let
But
the
the-
bench.
by the honorable full bench, in the case of Kapatapatra. And here the honorable
Navanita Kapatapatra.
Navanita Kapatapatra. And here in the honorable single judge has held that resolution shall be treated as a proposed resolution.
Section.
I'll take notice because private party.
Mr. G requires consideration. You accept notice.
Lordship, no problem, my lord. I shall accept notice. But
Private parties are there. I will take
Yes.
notice to
Of paragraph
opposite party
20.
number 3 to
Paragraph 22 of the judgment, your lordship, may kindly see.
3 to 26.
Paragraph 22. Honorable Court has
Refer to Srimati Kamala Tiriya.
Yes, Kamala Tiriya. Agreement resolution was passed unanimously. The decision moved no confidence motion against the petitioner. It was received with a requisition, and the substance of such resolution is with a clear intention expressed by the elected councillors to go for a special meeting, and the same having been received by opposite party number 2, it has also held that it is in compliance of section 54(2)(c) of the Act. The decision of Kamala Tiriya is distinguishable for the reason that there is no proposed resolution and requisition has not been sent by all members of the GP, and with deficiencies.
Requires consideration because identical matter myself,
your lordship,
house have admitted another matter.
My lordship, your lordship's order, this order is in consonance with your lordship's order. That is what. That is the division.
No, this aspect is not considered at all. Even he is wrong.
Yes.
This aspect is not. That is the reason why learned single judge has not referred to that decision. In reasoning part, which now we have read,
Yes,
he goes not on that. So it goes contrary to the text of the statute.
my lord.
It
54.
requires consideration.
But this
My
judgment has come
After that.
right to that.
Yes, yes.
Right.
That's reject. Judgment.
That comes later.
My lords has rendered the judgment in 3 bench, my lord.
Correct. But this case was decided.
Right.
In view of Prahlad Dalai's case, has been accepted.
So no scope.
Heard.
But no interim order be given.
I
have not sought
not
for-
sought for it.
I have not sought for.
Issue notice. Learned DG, Mr. G, on our request, accepts notice for fee numbers 1 and 2. First up, member committees to the rest. Refugees in 3 working days. First up, matter lies in a narrow compass, posting in the second week after the end of vacation. Summer vacation. Okay. Next.
Okay, we appeal 1510725.
Yes, Mr. Vishnu.
Petition is at the checkered career. The long story short, my lord, the petition was entitled to granted with effect from 1694 at that 1/3.
But learned single judge has restricted it to 3 years.
Restricted to 3 years, my lord. What happened relating to relevant basing on the Supreme Court order, my lord? But Supreme Court order, Lord Smile. Supreme Court order clearly says that if they already compliant, no recovery shall be made. In this case, my lord, what happened? 8922 of 2013 writ petition when the order was not implemented, terminus order not implemented. With the filed writ application. Writ application, the government itself filed a counter saying that we have complied the order. They'll also kindly see that document, my lord, that counter, my lord. My lord, that's a 2-page. My lord, they'll also kindly see the execution case and
Unconditional compliance affidavit.
case conditional affidavit. That is at page 16. At relevant page at page 20. And basing on that, this honorable court dispose of the application. Page 20, my lord, LC. That in meantime, the principal of the college, LC got it, madam.
Yes.
Under question was requested to furnish the entitlement of the person as per the relief granted by the London Tribunal, and response he submitted some final application to the tune of so and so due to petitioner white letter number so and so, the photocopy with said letter and with financial implication furnished by the principal. Then my lord, the next to para 8. Last sentence. Since the compliance is
Kind order.
yes. The compliance order dated 6/8/2010, London Tribunal, in GI case number so and so, kind order dated so and so, it's passed by the honorable court.
Gee, requires.
It requires, my lord, lots of issue notice.
Heard the senior advocate, Mr. appearing for the petitioner.
Appellant.
Appellant. First up, issue emergency notice. But learned AG, Mr. G, on our request, accept notice for the OP numbers 1 and 2, emergency notice to 3. Matter lies in a narrow compass. Post in the fourth week of July 2026. Deployed. Next.
Yes, I'm there.
What is this matter?
This is a matter, my lord, where Honorable Court has,
To comply with the order of the tribunal.
my lord,
Orders of the tribunal have to be complied with.
my lord, there, but what the direction is made, the tribunal's order is, my lord,
Yeah.
according to lordship, may kindly have a look. Page 38,
38.
where is allowed, the respondents are directed to modify the order at Annexure 3 and the applicant be given a grant pay of 2,400 was first RSCP with effect from 1/2013, 1/1/2013 and grant pay of 4,600.
Yes, that is the order. Is it set aside by any court? In SP Sampath Kumar and L. Chandra Kumar, what the apex court said, tribunal is a substitute, virtually a substitute for the High Court.
My lord,
If that is so, you have to comply with the order. Did you oppose that the writ, saying that we will not comply with this order?
the Honorable Court has said that to implement the order.
Yes, implement the order.
My lord, here,
And sir, definitely meant for implementation,
Yes.
for calendar purpose.
yes, here, my lord, this,
You are not before the court. You are not the order in challenge. Read 92 Supreme Court.
right.
You are not the order in challenge. It is bound to be compliant because now there is no tribunal. Where is
There is no tribunal.
Then this court has jurisdiction.
My lord,
Within what period he will comply with this?
here, my lord, this petitioner was appointed as a village forest worker. That was a scheme, but
That is reduction. Mr. G,
It was
is
not-
an order. Order is not complied. Learned single judge says comply with the order. What is wrong with this order? Where is the wrong? No, absolutely okay. In fact, we should impose for filing such frivolous appeal, your officer should be hauled up. They have not laid a challenge to that order at all.
my lord,
Order has attained finality. Learned the tribunal in OA number 3224 of 2018, while the order dated 2 and 3 January 2019 had granted the relief to the respondent employee. First, the operative portion of the order reads as under. That in view of the ratio residing insurance according to the road. Next paragraph. The tribunal came to be abolished, and therefore there is no forum for enforcing its order. First, consequently, the employee who happens to be a respondent herein rightly invoked the jurisdiction, constitutional jurisdiction of this court, keeping in line with SP Sampath Kumar versus Union of India 1987 and L. Chandra Kumar versus Union of India 1997.
98.
No, 97. Learned single judge by the impugned order has directed implementation of tribunal's order. First off, despite vehement submission, no case is made out for our interference, in as much as the order passed by the administrative tribunal under section 19 of the Administrative Tribunals Act 1985 partakes the character of writ, which the writ courts exercising 226, 227 jurisdiction do render. First off, when enforcement agency does not avail in law, it is the duty of the writ court to enforce the statutory orders of tribunals of the kind which are treated almost on par with writ courts. In view of Sampath Kumar and L. Chandra Kumar Supram. Regardless of arguable lacuna in the said order, wrong cannot be attributed to the learned single judge who has directed its implementation, the said order having attained finality for all practical purposes. And this accords with a three-judge bench decision of the Apex Court in AR 1992 SC, page 111, paragraph 567. First, next one. In the above circumstances, this intra-court appeal fails, coupled with the direction to the petitioners to implement the impugned order of the learned single judge within an outer limit of 8 weeks, without driving the respondent employee to another course of legal battle. First, we also notice that the intra-court appeal is moved after brooking a long delay of 376 days. First one, the application in IN number so and so 636 of 2024 is moved, seeking its condonation. First one, delay is long and explanation offered is not plausible, to say the least. First one, therefore application is rejected. Next.
Item 10.
Petitioner to send a copy of this order to the respondent employee by speed post immediately for his file.
Item 10, your lordship may kindly take up this matter next week.
Next week, on request.
Item 11. Read of the 890 of 2024.
My lords, this is state appeal. My lords, kindly come to the impugned order. It is very short order. My lords, the petitioner was...
As on the date of retirement, no proceeding was pending.
My lords,
pending.
It was pending.
Show that.
Charge sheet was filed.
Show that.
In the order itself, it is mentioned.
Cognizance was taken, final form.
Cognizance is... My lords, there are two sections.
Request consideration. Issue.
My lords, there is delay of...
Therefore, we'll issue for
My lord.
Issue. Emergent notice. If the appellant deposits rupees 20 per day of delay in the registry within 2 weeks.
3 weeks.
3 weeks. Failing which, the application stands rejected, and as a consequence, the appeal as well. Okay.
Item 12. Read of the 1769 of 2024.
Yes.
May I please?
Yes, sir.
Sir, my lord, I have challenged the very initiation of departmental proceeding against the petitioner on the ground that department fellows will turn to Rule 836 of PMR. There is a provision that if one earns 9 black mark, a proceeding will be drawn up against him either for removal or reduction in rank or dismissal from service or compulsion. 4 punishments are provided under Rule 836.
Reduction in rank, discharge, dismissal, removal.
That proceeding was initiated against me. I challenge the very initiation that I have not earned 9 black mark.
You have not earned
9 black mark. Only on
9 black.
Only on earning of 9 black mark, a proceeding will be initiated under Rule 836 of PMR.
How many he had earned?
They have
Yes.
they have calculated it 10.
10.
Yes, ma'am.
Is there any block period prescribed for that?
Yes, ma'am. They have calculated it 10 as per the judgment of Tribunal, as well of my lords, that the black mark which has equivalent value.
All they should be of equivalent value.
Yes, no, 3 black marks having equivalent value.
Out of 9.
Out of 10, my lord.
Out of 10.
My lord.
3 should be of same value.
The equivalent value means what is that punishment? If one increment is stopped for 1 year.
For other 2 also it should be same.
No, my lord. If increment is stopped for 1 year, that is equivalent to 3 black mark.
Other way. Other way around.
So that once that period is gone, it's that 1 year is gone, that black mark goes.
Vanishes.
Yes. And that is the decision of the land tribunal.
No, that stands to reason also.
And also that has been confirmed by my lords also. I said it because 3 black marks having...
You take notice.
I hear my
let kindly see the order. Let him it was just given in opportunity to
I am challenging that.
Initiation itself.
Yes,
you can tell it the same thing to them.
That is the order. That is the order.
The learned single judges reason now.
Yes, Lawrence, Honorable single judge has said, I have to file already I have filed so cause reply. After filing of the so-called reply, when they appoint the inquiry officer, I approach the tribunal that was transferred and Honorable single judge said again to file a so-called reply.
No, that
will make it clear. Don't worry. We will treat this as a proposal. To that proposal, let him file the objections. Fairly, they should consider. If you suffer an order, come to go before single.
No, my lord, I have already filed the so-called reply.
Then they will take.
After that, they have appointed the inquiry officer.
That is the order, my lord. Can you see para 7?
If the very initiation is under challenge, because only they can initiate the proceeding if I will earn 9 black mark.
No, whether these things are there or not.
In my so-called reply, I have
they should consider and they should take a decision.
Yes,
on that. Have they taken the decision?
No, yes, they have taken the decision and appointed the inquiry. Yes, ma'am.
Have they rejected your content?
Well, once they appointed inquiry officer means...
No, whether that order reads that way.
Yes. They must have given it in the order that your explanation is not satisfactory.
They said?
Yes, ma'am. That must be in their file. Because unless...
No, we'll make it clear. Regardless of the appointment of the inquiry officer, they should consider your reply in terms of the learned single judge's order, then proceed with the things.
In the meantime, my lord, they have issued me second so-called notice for dismissal.
That inquiry has already proceeded.
Yes, that's I am submitting.
Otherwise, there is no scope.
You don't take any precipitatory action till his reply is considered.
Yes, ma'am.
All right.
Well, let's kindly see the order.
That's your argument.
Yes, madam. Yes,
we are telling your argument.
My lord.
In compliance to order of Honorable single judge.
So by the time this order was passed, this inquiry had already completed.
No. Inquiry officer was appointed.
Therefore,
yes.
That they have rejected my reply. That may not be, that gives scope for this one. See, all these problems arise because of your ill draft. The orders are ill drafted. You should have said, your explanation has been perused. We do not agree with that. Therefore, appoint the inquiry officer, let him come to the witness box. That would have been the correct position. Therefore, this intra-court appeal by the delinquent employee calls in question a learned single judge's order dated 8/5/2024, whereby his WPC OAC number 2334 of 2017 is practically negative. Kindly be seated. Next paragraph. After service of notice, the official respondents have entered appearance through the learned AGA, who vehemently opposes the appeal, making submission in justification of the impugned order and the reasons on which it has been pending. First, learned AGA draws our attention to the operative portion of the impugned order to the effect that there was no cohort cause of action, and therefore learned single judge has relegated the appellant to the inquiry officer, to the official respondent. First off. Next one, having heard learned counsel for the parties and having perused the appeal papers, we grant a very limited indulgence in the matter only to the effect that the appointment of the inquiry officer shall not be presumed as overruling the reply submitted by the appellant employee to the proposed disciplinary action. And that till his reply is considered, no precipitatory action shall be taken against the appellant. First, with the above observations.
Only one line, taking into account the ratio decided in the state of Odisha versus Sankarshan Gulf.
With the above observations, appeal is disposed of.
My lord, there was a delay. Your lordship may condone that.
Condone that. Yes. Short delay of how many days?
18 days.
18 days.
Delay from
Next. And the rest of the things impugned order stands intact. Yes. Okay. 1-3. Yes, Mr. Behura.
My lords. My lord, this is Sarar Parida. Your lordship has fixed to some other day.
How many days of delay?
It is
6 not 3.
My lord.
A deposit 13,000 odd.
My lord.
That order. 3 weeks. First, if money amount is deposited, then it is goes. Post it immediately after this for possible dismissal.
My lords, this appeal, my lords, it is order to reconsider in terms of a judgment. So, my lord, I. The matter was remanded. That is why your lordship may.
Order is set aside and matter is remanded for fresh consideration. Next one.
A delay of 384 days.
This intra-court appeal, no, 470, by the state and its functionaries, seeks to call in question a learned single judge's order dated 21/11/2023, whereby respondents WPC number 4183 of 2023 having been favored, the relief has been accorded to him as under. Go to the relief. Next one. The appeal has been filed after brooking a long delay of
384.
No, 417 days.
Not 470. Page 15, item 15, my lord. This is item 14.
Page 15. This is item 15. 14 it is. 384 days. And an application in IA number 159 of 2025 supported by affidavit accompanies this. First, a perusal of the application and the affidavit would not make out a case of plausible explanation, delay being long. First, therefore, we decline to condone the delay, and as a consequence, the application stands rejected. Next matter. We have heard the matter on merits. First, the text of the impugned order would show that what has been done is that the matter is remanded for consideration afresh on normative basis. After setting aside the order that was challenged in the said writ petition. Order dated 7/2/2020. Challenged in the said writ petition. First, ordinarily, in remand orders of the kind, appeals are not entertained subject to all just exceptions, into which case of the petitioner's appellants does not fit. First, in the above circumstances, this writ appeal fails. Registry to send. Right. Next.
In this item, I have instruction to appear. Because this is matter arising out of a common judgment. Two more matters are also there, arising on a very some common. That will be taken up tomorrow or day after tomorrow.
We'll call them these matters also, so that one.
Yes, Your Lordship.
See, two more.
Call along. Oblige, Your Lordship.
Next week?
Day after tomorrow.
Day after tomorrow, we have posted many.
Next week. Next week.
Little easy day. 20.
Oblige.
Yes.
Have you seen? Need of it, the similar would not notify?
Items.
Yes.
16 it is a state appeal, my lord.
State appeal.
But the similar matters has been decided by this Hon'Ble Court, which was referred to the Hon'Ble Apex Court, my lord. That my learned friend has
Mr. A. Martin.
annexed to the counter affidavit.
Do you have copy?
Well, Mr. A. and Mr. Inman.
In your counter?
Counter. Judgment of coordinate bench.
Coordinate bench. Where is that?
Petition
or with appeal?
Counter affidavit.
Counter affidavit in writ petition.
No, this is
In 1/6. Do you have a copy of the order, sir, with you?
Next counter affidavit.
Kindly give, pass on your, we may recall our, if it is our order. Recall means remembering, remembering. Coordinate bench has our matter. That matter is covered, Mr. Moonfield.
well, thereafter also
Matter is taken to Apex Court.
Apex Court. my lord.
It is pending.
Then that Narasu Pradhan and other matters which has been decided by the
Pradhan. It's good.
She decided in that G. Balkrishna, my last occasion, my pass the order.
Do you have a copy of that order?
I have
Yes, my lord.
I have
That is also annexed at page 58, my lord, into their counter response.
No, that was Balabhadra Naik which you have said, no?
Balkrishna, I have management.
Index is not there. You know, Apex Court has also affirmed that one.
Well,
Ramakrishna.
In that index, it is at page 58.
The subject matter of this intra-court appeal referred after broking a long delay of
This is of 419.
419 days is substantially similar to the one in writ appeal number, just so that one in writ appeal number so and so between so and so decided by a coordinate bench of this court wide order dated
25 August 2025.
25.
August 25.
Well,
whereby appeal of the kind has been negatived. First up, we are told at the bar that even similar view has got imprimatur of the apex court in SLP number.
well, SLP number and dial number 2.
SLP diary number
33400
33400
by 2023
of 2023
between
State of Odisha and other
Odisha versus
G. Balkrishna
G. Balakrishna
and other similar matters. This is decided on
24/7/2025.
24/7/2025. First off. Next one. It has been a settled position of judicial process that like cases should be treated alike unless demonstrable differences do exist. First off. Despite vociferous submission of learned DGA, no such demonstration is brought about. First, in the above circumstances, this appeal fails, coupled with a direction to the appellant's hearing to comply with the impugned order of the learned single judge within an outer limit of 8 weeks. 8 weeks. Reckon from this day. Without driving the poor employees to take up another round of legal battle.
There is a delay of 405
405. What is this matter, Mr. Mohanty?
But here, Miller, out of the similar matters, may I pray?
No. Other 5 matters are also readable. You let it come along with next week, your lordship.
Call those matters also.
Yes, Miller. I'm giving the number.
Call this appeal along with
509.
so on which date, brother? 18th.
18th.
Item 18, legal appeal 1550225.
Yes, sir.
My lord, state appeal
Mr.
involving delay of 213 days. But the merit of the case, my lord, paragraph 7 of the impugned judgment, page 29, running page, your lordship, kindly have a glance. Page 29, paragraph 7. The Honorable Single Judge had relied upon a judgment order dated 7/9/2023, passed in WA number 1739 of 2022, and following that judgment, as the government has implemented that judgment, that order, the Honorable Court has granted the similar relief. But we have taken a specific stand in this writ appeal that that case is not applicable to this case at the distinguishable facts and circumstances.
Show that.
My lord, for that, my lord, many writ petitions have to be referred, and the rules which has earlier given the 27% reservation to SCBC, which was changed, and the implementation of model code of conduct, etc., I have to call for that file, and I have to scrutinize the file, and thereafter I will make a foundational facts, my lord.
When will you do that?
My lord, next week, my lord. Next week.
Let it come after vacation. Next week not possible because
Last 10 years, Milord, we are suffering.
Thought will be required because there are complex facts, my lord.
at the request of the DPM.
Next week, here your lordship also indicated that item 47 of weekly list. My lord's list.
Similar matter.
Same matter. The batch of matters, my lord, they have filed the writ appeal.
47.
47.
47 is the weekly list.
Weekly list, your lordship already indicated in that item number 18.
Petition, we have filed many writ appeals. All the writ appeals may be tagged, my lord. So in 47, all these matters.
Ah,
Yes, all these matters.
You argue on 18th.
18th, my lord.
18th.
And my lord, in this
Check that matter.
the connected WA 1423, which is referred in the list but has not been listed, maybe specifically 1423. That is there in the list already.
Also call writ appeal number.
Sanjeev Kumar Pohan.
That has been deleted.
Listed, not 47, but only referred. It has not been referred properly. That is to come.
We'll
That
come
will come along with the batch.
There also kind
18.
From 19,
Wait.
1 and 1 for 150.
Ma'am, I'm here to close. Here, my the matter relating, so I'm challenging the order of the Lord and Central Tribunal, my lord. The matter relating to the appointment under the on compassion ground. The fact of the case, my lord, the petitioner father, while working as under the opposite party Steel Authority of India, he suffered from cancer and ultimately died in 1998, man. On 22/8/1998. The three more dates are relevant. 1965, the father of the petitioner appointed as storekeeper. 96. Regular basis.
1 second. Kindly give us the dates, full dates.
Full date.
When was he appointed?
Appointed 1965, it was mentioned.
No, we don't say. We'll not entertain. We'll adjourn this matter.
No,
We are not giving the date.
Well, the appointment date is not there, only appointment.
How to decide that? So many aspects are there. Somewhere it will be there. Just turn the pages.
I'm gone through my lord.
No, you say that it is under sale, no?
Yes.
Steel Authority of India.
Yes.
Then
Then there is no dispute with regard to appointment.
Will you not convince us?
Well,
Can you sell Bhubaneswar?
even the interim order, my lord, has been reflected paragraph 2. The applicant's father, namely so-and-so, was appointed storekeeper in the year 1965. The date was not there. But
That was there, but there is, in your state there is a culture of not giving the correct dates at all. Just giving the year. Give century.
she continued, 65, she continued till my lord, on 12/7/93, when he suffered suffering from cancer.
65 as?
A storekeeper.
And died on?
Died on my lord 22/8/98.
In harness.
Harness.
22/8/1998.
That is Annexure 4, page 44.
As storekeeper only.
Storekeeper.
65 up to 95, how much it will be? 30.
30.
Plus 33.
No, he was also promoted to L9 grade.
Therefore, I am asking you on which day, or as on the date he died, what was the post he was holding?
That is the L9 grade.
L9 grade.
Storekeeper in L9 grade.
Then what happened?
Before the death, my lord, on 12/7/93, he was suffering from cancer, for which the medical officer already detected and found to be suffering from cancer.
In 93.
12/7/1993. Annexure 1, page 22.
Why suffocation is happening in the court? We see not that. Yes.
Thereafter, after the death, my lord, the application was submitted for compulsory appointment on 27/11/98.
27/11/98.
98.
That is after 1 year.
Well, that is what, after 1 year.
What is the period within which one has to apply for the compassionate appointment?
That is in the circular, the government under the circular. Circular, there is no restriction for limitation period. Only certain criteria has to be fulfilled to get the appointment of the compassionate job.
So any time they can apply.
So that the circular says only page 58, I'm including the circular, which says the condition.
The company has got its own circular.
Yes. That is page 57, Annexure 8.
What it says?
That is the Steel Authority of India Limited, Raurkela, issued circular on 1/1/96. That was governing at the time of death. which the stipulates the condition for extension of benefit of employment on compassionate ground under first priority in certain cases in update.
1196.
1196.
Guidelines.
The guideline.
Because that it will it not mention the limitation.
So
Why is that? Limitation is in the court one. Whether any limitation period is it's a government company.
Yeah, Government of India.
Government of India company under section 617 of the Old Companies Act.
Yes, yes. And the three conditions, my lord. The three conditions, my lord.
Yes.
The three conditions to get the appointment on the compassionate ground. One is the employee if died due to failure of kidney, heart attack, heart stroke, and cancer. These are the three.
Cancer also included.
Yes, yes, three conditions. Only three count.
Heart
and cancer. That is there in page 58. Clause 2.1.
Yes.
After I made application 98, they rejected my claim initially on my lord. They initially directed to submit application on to certain documents related to my qualification. That is on 15/1/2000. And except 4 my lord.
15/1/2000.
They called for
you had applied on 27/11/98.
Indeed. They have written a letter on 15/1/2000 asking the petitioner to submit certain relevant educational qualification to consider my claim.
15/1/2000.
That is Annex 5, page 47. Then, my lord, page on 21/4/2000, they have rejected my claim on the ground that I am not coming within the parameters. that 2000 order, I challenged before this court by filing OJC number 1747 of 2000.
That order is dated, that the order, the rejection order?
Rejection order dated 21/4/2000.
(21/4/2000).
And immediately I challenged the same by filing OJC number 1747 of 2000.
Decided what happened?
Man, that writ petition ultimately transferred to the London Central Tribunal by the order dated 17/2/2016. Because of the notification, all
transferred to CAT.
17/2/2016, and accordingly renumbered as TA number 16 of 2016.
TA number
16 of 2016. Now the London Tribunal passed the impugned order on 10/4/2023, saying that since the circular relying that government, the counter of the opposite party, saying that since the death of the father of the petitioner, the reason has been mentioned that due to bilateral pneumonia septic shock, therefore
not cancer.
But the authority, the very same authority, Annexure my lord, while issuing Annexure 1, also indicated that the petitioner is suffering from cancer.
Suffering from cancer is one thing.
Yes.
Death, reason for death is another.
Yes.
A person may be suffering from diabetes. Death may be because of heart attack. So one is suffering from cancer is no ground. Death by cancer should happen.
But
see, if you read standard medical books,
yes,
in everybody, cancer cells are generated periodically, but they are swallowed and therefore we do not suffer.
Yes.
But suffering from cancer is one thing, death by cancer is another.
My specific case, my lord, before the tribunal, that the petitioner, by suffering from cancer, ultimately died.
How
What
you,
the reason, my lord?
How you are not a doctor?
No, because all the
causal nexus
yes,
between cancer and death.
Yes. But I have included all this medical certificate.
There is a certificate which says death is due to X factor.
Yes.
If that is so, you do not fit into one of the three parameters.
Yes. That
Kidney, heart cancer.
Yes.
It is not.
But exactly the same issue was already decided in respect of very same organization, I have enclosed by that judgment in my memo citation. This issue has already decided.
Saying when he does not die by cancer, still it should be given.
No, there are not fancy one paragraph.
There is one famous book by H.L.A. Hart and Tony Hon'Ble, The Causation in the Law. One of the best books. What is meant by cause? What is meant by effect? What is the causal connection? What is condition? It's so beautifully written. It's a class, wonderful book on law, jurisprudence.
May I pray division bench of this court on my lord in identical matters relating to same organization. That is also that the organization stated.
Where is the relevant portion? Read.
In that case, argument was advanced that the death
Where
was
is the treatment? Read that one subject. We have you are all seasoned lawyers. We may not be that seasoned judges, but we can learn when you argue beautifully. When he died, he had condition of cancer.
Yes.
But not cause of cancer. There is a difference between condition of cancer and cause of death. If the causal connection is established by medical evidence, then you have a case. That is not there.
Then kindly follow the next week. I'll that the judgment matter on para 19. In view of the proposition of law as discussed above.
Where is the proposition?
Read
the proposition.
The proposition.
How they have discussed.
That judgment of the apex court, also in the very same organization, that is Balbir Kaur versus Steel Authority of India.
What it says?
Year 2000 Supreme Court page 1596 categorically held that sudden jerk on the family by reason of the death of a bread on honor can only be observed by some lump sum amount being made available to the family. This is rather unfortunate, but this is a reality. The feeling of the security drops to zero on the death of the bread owner, and on insecurity thereafter the regain. And it is that in that juncture, if some lump sum amount is made available with the compulsory appointment, the grief stricken family may find some solace to the men.
But when the sudden death, he suffered 12/7/1993 was cancer detected.
Yes.
And he died on which day?
Died on 27/11/19. 27/11/19.
No.
22/8/19.
22/8/19. 8/98. That is more than 5 years.
5 years.
Where is the sudden death? What is the object of compassionate appointment? Apex Court said the compassionate appointment the state will do because the breadwinner dies immediately.
Yes.
It's a death in harness. All of a sudden. And family will be ruined. There will be nobody to look after. Breadwinner is dead. That is the case of sudden death at all.
That is a case of natural death. They are saying that this will court held you consider in that circular.
We cannot draw a new policy. Let us see what Mr. Tripathi will say.
May I please, your lordships?
Yes, sir.
My lords, I may be permitted to appear virtually, my lords.
Yes, sir.
My lords, there are two aspects, my lords. Because my learned friend before your lordship challenging the order of the honorable tribunal, my lords. So neither he has taken a stand nor there is anything to show that what is the perversity is there, my lords. First. Second, my lords, your lordship, see my counter, I am relying only two documents, my lords. That is 1996 circular and the cause of death. That is, my lords. The lordship may kindly say.
1196 policy.
Yes, my lords.
Yes, he has said about that. Go to next point.
Page 59. That is
Go to next point. Don't repeat.
Next point is that your lordship may kindly see the death certificate, man. The annexure
It says not cancer.
Death, cause of the death, man. Death certificate. Man.
Cause of death is not cancer.
Yes, man.
Go to next point.
When the cause of death is not cancer,
the next point.
You have not heard. You have not heard us. We have been deliberating with the council. You have not heard us.
Don't repeat anything. If you want to add anything new, you are most welcome. Otherwise unwelcome.
My lords, when cancer was detected, he was cured from the cancer and joined back also.
He was cured also.
Yes, my lord, sorry.
In which stage of cancer and which cancer?
That is
What type of cancers are there? That was the cancer.
That is mild form of bladder cancer, my lords.
Bladder cancer.
Mild form of bladder cancer.
What was the stage? What was the stage of cancer? And that is the assistance we need from the bar.
Yes, so these are the only issue, my lord. And the circular is very clear.
We are asking you, what was the stage of cancer?
That is
First phase, second phase, third phase, fifth phase. What is the stage of the cancer?
That is phase 2.
Bladder cancer, how many stages are generally contemplated? These things we need research from the bar. You may be liar, but you should know the medical science also.
Correct, absolutely. You're also absolutely right. Absolutely right. So,
be seated. Kindly be seated.
Sorry, my lord?
Kindly be seated. No, not for you. You are already sitting. I can't ask a person who is sitting to sit there again. Your friend is sitting now. Take now. What was the name of that person who died?
That person name Atul Chandra Bose.
One Mr. Atul Chandra Bose, who was working as a storekeeper since 1965, was in the grade of storekeeper L9. When he was detected with cancer on 12/7/1993. Kindly be seated. And if we want any assistance, you can answer by sitting only. You need not stand up. This is not a primary school. You are all honorable members of the bar. First off, it is told at the bar that the cancer was cured and that he reported for full duty. First off. However, he met with his maker, M Capital, on 22/8/1998, and cause of death as per the medical certificate is not cancer. First of all. Next paragraph. The petitioner, being the son of the deceased, had applied for compassionate appointment on 27/11/1998 in terms of sales policy guidelines dated 1/1/1996. First off, the said policy guidelines recognize kidney disease, heart ailment, and cancer leading to death as the parameters for favorable consideration of the claim for compassionate appointment. First off, the sale-wide letter dated 15/1/2000 had asked the petitioner to submit certain documents, which his counsel tells us were submitted. First off, however, the claim came to be rejected by the order dated 21/4/2000, and that led to institution of OJC 1747 of 2000. First off, the said OJC came to be transferred to the CAT, Cuttack, And the case was re-registered as TA number 16 of 2016. First of all, the said case having been turned down, this writ petition is filed. Invoking Articles 226 and 227 of the Constitution of India. Next one. After service of notice, the OPs having entered appearance through their panel counsel resist the petition, making submission in justification of tribunal's order and the reasons on which it has been constructed. First, the panel counsel passionately submits that compassionate appointment is only an exception to the general rule of recruitment in public service, and therefore the policy conditions governing the same have to be scrupulously followed. First, he drew our attention to the policy as well. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the tribunal that the claim for compassionate appointment cannot be successfully made if cause of death is not an ailment relating to kidney, heart, or it is cancer. First, the breadwinner was suffering from cancer, the same having been detected on 12/7/1993 is not in dispute. There is a medical certificate of death which does not indicate that the cause of death of the breadwinner was cancer. First, no material is produced before us to show that the certificate of death, to the extent it mentions the non-cancer reason, is wrong. First, when policy specifies certain grounds for claiming compassionate appointment, such appointment cannot be extended. The horse, the policy, as rightly submitted by learned panel counsel appearing for the OPs. Next paragraph. Cause of an event is one thing and its condition is another. Which aspect has been thoroughly researched by two professors, namely H.L.A. Hart and Tony Hon'Ble, in their famous work, The Causation in the Law, inwards. First one, cause and conditions are two different things. At times they are poles asunder, to say the least. Cause is one thing and condition is another. At times, there may be blurred boundary line between these. First of all, even that has not been demonstrated before this court. First of all. Next point. The vehement submission of learned counsel for the petitioner that in more or less similar circumstances, a coordinate bench of this court in so and so has granted relief to the children of the breadwinner dying intestate, dying in harness, does not come advance his case. First,
That was a case where the death happened suddenly and the family was thus driven to distress by the bolt from the blue, which is not the case here. First one, the cancer was detected in the body of a breadwinner on 12/7/1993, and he died on 22/8/1998, and thus detection and thus the time span between detection and death exceeds 5 years. It's a long period. Nobody can be justified in saying that there is any proximity between the cancer and the death. When the death certificate issued under the provisions of Registration of Births and Deaths Act 1969 something has been issued. Act, personal. Such certificates arising in due discharge of public duties would raise some presumptive value, for the rebuttal of which some cogent material is to be placed before the court. First off, that has not been done. First off, long ago, it is Lord Halsbury who said in Quinn versus Latham that a case is an authority for the proposition that has been laid down in a given fact matrix, and not for all that which may logically follow from what has been said so laid down. First, in the above circumstances, this petition fails. No course. Next. Passover. He wants a Passover. He is on his feet. Passover. That book's publication, etc. I have to write, huh? So I think it's an Oxford publication. Just look into it. Go to Google and find out. Yes. Which one? 21. 21? Yes, you want time?
No.
Passover. Yes.
22.
Here the petitioner before your lordship is a auction purchaser.
Auction purchaser.
My lord.
Instead of 2 days time may be granted to file an affidavit.
I mean, in the auction purchaser was here, auction was held in 2024. I have deposited the amount. They have issued the sale certificate. But when they have gone to deliver the possession to me, it was found that instead of 42 decimal, it is now my 25 decimal. That's why I have filed this application to return my money, madam.
But where is the KVA tempter?
Pardon, my lord?
Where is KVA tempter on your part?
Immediately, my lord.
Oh, immediately. Where is due diligence on your part?
KVA tempter.
I only indicate the dates, my lord. Thereafter, your lordship will find out what is my due diligence.
Not date. Person, Mullah, on Transfer of Property Act, has given commentary on section 54 and 55 of the Act. What are the things which a diligent buyer of the immovable property has to exercise? When did he go to that one? When did he measure it? How? If you come and not say what we can do, madam.
It is a condition that after the deposit of money, they will demarcate the land and will hand over the possession.
So you agree to it after the sale?
After the sale. Therefore,
You got the sale deed.
Only sale certificate was issued.
That's what. That's referring to.
It has not been registered in the sub-registered office.
You are not answering the point.
Yes, ma'am.
If you do not want to answer, well and good. But with due respect, Nani, when court asks some questions, our intention is to do justice. Or we can pass any order anyway. That's very easy. But point is, yeah, that's good. Point is, you got the sale certificate. Whether sale certificate is registered or not is another thing. When you got the sale certificate, you agreed to the contents of the sale certificate because sale certificate is prepared with your participation. They give measurement, everything they have given. What is the measurement in the sale certificate? More or correct?
Measurement in the sale certificate is not there. Only the sale certificate indicates I have paid the money.
But they say that they have given you the physical possession in the sale certificate.
No.
Yes.
No.
The undersigned acknowledged the receipt of the
See
sale.
page 13, my lord. Sale of the scheduled property was made without being from performances listed below.
No, that is there. But the undersigned acknowledged the receipt of the sale price, such and such, in full and hands over the physical possession of the scheduled property.
There.
In full hands over, this is the sale is on. Thereafter, my lord, last, the sale of the scheduled property was made without being from encumbrances listed below.
Point is, you have taken the possession of the property. Apex court said,
Till
possession of the property is taken. Resumption is, you knew the dimensions.
Till today, I have not taken possession. Thereafter, next annexure, your lordship.
There is a certificate.
Your lordship will kindly see the next annexure issued by the bank.
Annexure 4.
Annexure 4. With due respect, the humble submission, I beg to state the following properties were mortgaged in our bank for loan purpose. Since the borrower has failed to repay the loan in time, bank has started recovery to so-and-so against the borrower. However, the exact location and the exact land is required for further course of action. Hence, you are requested to depict one commissioner for identification of the mortgage land. This letter was issued by the bank. Thereafter,
sale certificate is a product of process of law. The sale certificate, Apex Court said, is a product of process of law. Therefore, and that certificate says you have been put in possession of the property. Subsequently, what letter correspondence takes place between bank and some revenue officials, we cannot act upon all that.
The bank, my lord, who has put the property into auction.
You have bought it. And you got the sale deed, sale certificate.
Sale certificate.
Sale certificate is equated to sale deed by the Apex Court. And therefore, there is an accomplished contract. One best thing what we can suggest to you is, you can file a suit for damages. And that liberty we can give, not beyond that. There are two judgments which may come to your help. One is Allahabad High Court, another is Allahabad High Court judgment by Dhawan, Justice Dhawan. Kerala judgment by Justice Potti. Very marginal cases, they have granted relief, not in writ jurisdiction.
The sale schedule was made without being from encumbrances, my lord.
Encumbrance is
This
another.
means, my lord, the casino.
Encumbrance is different from extent. Extent is different from encumbrance.
Now they are, my lord, saying.
File a suit, will give you liberty.
My lord,
We'll also say that limitation period which you have spent here should be discounted.
No, the limitation, my lord, the 3 years is also with me, my lord. With the 24, there are 3 years is with me. But my lord, the bank is still, my lord, to deliver the possession.
That will not be. Because the presumption is that there is a sale certificate. It's a statutory certificate drawn under Rule 9(6). And Apex Court equated sale certificate to the sale deed.
So-and-so regarding so-and-so, Not only shown in the schedule secured in favor of the Punjab National Bank, where the so and so loan account so and so. My lord, that sale certificate
And hands over the physical possession of the scheduled property. This is on as is, where is, as is, what is, and whatever there is. They have used all words in the dictionary for their protection. Regardless of that, you may get some justice at the hands of trial court, not just.
So whether, my lord, I will only examine whether in the sale certificate that within the physical position has been handed over to him.
Yes.
Whether it is, my lord, symbolical position or actual.
No, it was a physical position. They already said that. Physical possession
That
of the scheduled property is given to you.
that only I will examine. Whether writing, my lord, thereafter the developments I am showing to your lordship.
Essential grievance of the highest bidder in the public auction of security property given for securing the repayment of the loan in question relates to lesser extent of the said property than what was projected in the auction process. First one. Learned senior advocate.
I am not senior.
We treat you as senior advocate. Learned senior member of the bar. So and so vehemently submits that there is a covenant arising under sections 54 and 55 of the Transfer of Property Act 1882 to the effect that whatever has been projected as the property should be the property given to the buyer. And that having not been made out, interference of the writ court is eminently warranted. First one. Learned counsel Srimati, Miss. What's your name, daughter?
Rashmi Pradhani Lakshmi.
So and so, per contra, opposes the petition, contending that the property having been auctioned, the sale certificate also has been issued to the petitioner on
13/3/24.
13/3/2022. 24. And it makes it abundantly clear, even to a blind man, that the property is given on as is, where is, as is, what is, and whatever there is basis. First of all, she also tells us that the doctrine of caveat emptor tilts against the petitioner, and therefore no relief can be granted to him. Having heard, kindly be seated. Having heard learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned panel counsel, Miss So and so. First off, sections 54 and 55 of the 1882 Act specify rights and duties of seller before the sale, seller and buyer of an immovable property before the sale and after the sale. First off, several high courts in the country have taken the view that the doctrine of due diligence has to be invoked on the principle of caveat emptor in matters like this. First of all, the next paragraph. The above apart, the certificate, sales certificate has been generated in the process of law, namely by operating Rule 9(6) of some rules take out the title of the
Surface is surface.
Surface,
So right. First, such products of process of law enjoy presumptive value, and therefore the rebuttal aspect cannot be examined by a writ court exercising limited jurisdiction under Articles 226 and 227 of the Constitution of India in the light of Apex Court decision in Lodh, LODHE versus New India Assurance Company. That was the Lodh, LODH. New India Assurance Company, something like that. Apparently, there are disputed facts which again cannot be, Apex Court, which again cannot be deeply examined by this court, keeping in view the conventional limitations that inhere. First, in the above circumstances, this petition is disposed of, reserving liberty to the petitioner to work out his remedy in a properly constituted civil suit. First, in that connection, all contentions are kept open. First, it hardly needs to be stated that the period spent in prosecuting this petition is liable to be discounted while computing the period of limitation prescribed in the schedule to the Limitation Act 1963 for suit of the kind. No course. Next. Yes, sir.
May I challenge the order of the Honorable Single Judge where the
election matter?
Yes.
Yes.
May I here the election of the present opposite party number, respondent number 1 on recounting.
He is the returned candidate. He is the who won the election.
He won the election on the basis of the recounting.
He is called the returned candidate.
Returned candidate. But he has won on the basis of recounting. Recounting was challenged on the ground that
before civil judge.
Civil judge.
In an election petition.
Election petition.
That is a EP number.
That is my lord EP number. Just election case number 1 of 2022.
Election miscellaneous case number
2022.
1 of 22. And this is filed under which section of which act?
This is under the provisions of the Gram Panchayat Act, my lord. That is section 30, 31, 38. Orissa Gram Panchayat Act.
Sections 30,
31, 38. 30 speaks of presentation of petition.
30, 31 and
38, 38. In fact, my lord, 31 speaks of my lord, presentation of petition. 30 speaks of that it should be by way of a election.
What are the grounds on which election can be challenged?
My lord, here it was challenged on the ground that this recounting was ordered on a petition where no reason was assigned in terms of Rule 51 of the Orissa Gram Panchayat election rule, and the election officer also allowed the recounting without assigning any reason as mandated under the rule.
How that argument is treated by two courts?
The learned trial court rejected the argument and dismissed the election petition.
No, what is the reasoning of the trial?
The reasoning, your lordship will kindly turn to page 41.
41?
9. He quotes Rule 51, then refers to several decisions in different paragraphs only, and thereafter, in paragraph 24, he only says that I have failed to establish the election case, whereas the appellate court has dealt with it in extenso with regard to this infraction of Rule 51.
Whether recounting was sought for?
Recounting was sought for by the
other side.
Other side.
Correct.
But my contention was it is not in accordance with Rule 51. Rule 51 says
51-2.
51, yes. That is of the Orissa Gram Panchayat election rule.
That you have said, no? 51-2. Read 51-2. After the declaration under sub-rule 1 has been made, a candidate or in his absence, his polling agent may apply in writing to the election officer to recount the votes either fully or in part, stating the grounds.
This is very important. Stating the grounds for such recounting. Then the allow is to be made also by assigning reasons.
Where is his application?
The application, he says, so the appellate court said there was no application after the declaration of the result. It was a pre-declaration of result. But the learned Hon'Ble single judge has been pleased to hold that there was an application. But the application was without reason, that is Exhibit B.
Exhibit B. Page number?
But that you have, you lost it. Pardon me, that is not part of the writ appeal.
Whether application was made after the counting or before the counting?
And the Hon'Ble single judge has said application was
according to you.
But I will not dispute that it is after the counting also. But my contention would be it was without any reason, even a bare perusal of the application.
Let us face that application.
And then there was no reason also for allowing the same.
He need not, courts have taken Chapalgaonkar on election law rights. For recounting, separate reason need not be assigned. The court justice Pence's judgment from the High Court.
Your Lordship sees the appellate court judgment, how it has dealt with.
No, let us see the original authority, how he has said.
Original authority only paragraph 24, Your Lordship.
Which is, no, where is the application?
My Lord,
two grounds you are raising. One is application does not have grounds. Number two, the order directing recounting has no grounds. These are the only two grounds. Let us see the first ground.
My dear Lordship may take up after recess. I'll just get that document. My assisting counsel.
No problem. I was initially filed a caveat in the matter. I had initially filed a caveat, but if although copy had not been served,
where is any interim order is granted?
No.
Then where is the question of claim? He is not claiming for interim order. Are you claiming for interim order?
No, interim order I think will be at this stage very unreasonable manner to claim an interim order.
And caveat dies. Caveat commits suicide after 90 days. In our state.
Yes.
So what is the position in your state?
It's 60
days only.
60 days.
60 days. Okay, 60 days. Then where is your caveat? It is winnowed away by tempest. Yes, sir. Just
only those two documents, namely election officer order and the exhibit application.
If possible, bring that judgment of Justice Pence. It is referred to by Chapalgaonkar on law of elections, a very famous book. In that it is referred. Anyway, now you come with whatever you have said. Yes, Mr. Mishra.
I'm meeting with Lordship with reference to Rule 51. Your Lordship
51-2.
51-2 and 3 also.
3 also.
2 is with regard to the application being made with reasons why it should be done. 3 is with regard
to election officer is authorized to decide.
3 and 4. I'm just placing it also for your Lordship's kind appreciation.
No, 4 says it should be reasoned decision, it should be in writing.
Yes.
3 says he has to take the decide the matter. That appears to be considered
Your
judicial.
Lordship may kindly see the application and how it was ordered to be. My Lord, with Your Lordship's kind permission, may I file it, my Lord? Your Lordship sees this was the first application, the second page.
Please read.
I bring to your notice that in ward number so and so, GP counting has not been done properly.
Yes.
5 to 6 ballots, wherein votes are given by means of LTA mark illegally, counting in favor of CHITTARANJAN, the appellant, Senapati. Those votes should have been treated as invalid votes and should not have been counted in her favor.
Correct.
In favor of her. Similarly, 2 to 3 valid votes of Radharani Behra has been counted in favor of Sittarani Senapati. I being an agent of Radharani Behra, there is objection not to accept else these ballots in favor of Sittarani Senapati, but my objection has been ignored. Now, this is, Your Lordship, as vague as possible because he has to say where it has been done. Leaving aside that also, this document has not been accepted by the election officer.
Yes.
Your Lordship sees how the election officer has ordered. That is the last page. This application he again makes, saying that I had made an application earlier, you have not considered.
Yes.
On this application,
Yes.
at the extreme left top, recounting considered. So whether this can be considered as a reasoning? This is the thing, man. There is no reasoning.
In one case in Karnataka, old Mysore, there was an application seeking permission to open a wine shop. The authorities say, Mysore being the cultural capital of the state, there being already numerous arak shops, it is not proper to add one more to the same. And this went to the apex court. On the ground, one great lawyer, he was called as Rita Yenga, he was known for filing writ petition. Justice Ramajoyce Senior. He said it is not a speaking order. Then the Chief Justice of the High Court said, can there be more speaking order than this? He said, Mysore is cultural city. There are already arak shops, wine shops. To the existing number, one need not be added. What else can be there? Here, judicial officer is not making this order. It is some Tahsildar, Assistant Commissioner of that level officers will make this. Therefore, he says, recounting considered.
Madam, one thing I beg to point out to Your Lordship.
Yes.
My Disciplinary Court and as well as the Hon'Ble Appellate Court has been pleased to say that in a case of recounting, the specifications are required. If the matter is
RP Act, perhaps.
even
Under representation of people under 1951.
Even that has been also taken note of in GP Act elections, and it has been said where there is like he is saying 2-3 places. So this Hon'Ble Court has been pleased to hold. He has to specify which booth where it has been done. Nothing is spelled out.
Which are the voters?
No.
In the application?
No. He has not said. Your Lordship, may kindly see. Nothing, no specification.
The ward number?
Kindly.
Your Lordship, may kindly see.
What number has been given?
Your Lordship, may kindly see.
Number of votes, ward number, to whom they should have gone.
No,
like that.
Your Lordship
is not making a judgment.
No, I'm not
application.
It completely lacks specification in my humble submission. Secondly, there has been a statutory mandate, and it is not a case of.
In the very first sentence he starts, I bring it to your notice that in ward number,
9 of these, but this is one. Your Lordship, see, this application was not accepted. That is what is noted by the land trial court also, so also appellate court. Which application has been accepted is the last but one page, last page. And therein he says, recounting considered. And if your Lordship reads the provision itself of the GP Act, it says, even assuming that he has given a reason, let us take it that way. Then also, the election officer has not assigned any region. And 39
Whether this appeal is under 227.
My humble submission, this has been held by the Honorable Court. This is under 226 and writ appeal is maintainable. Successive decisions of the Honorable Court, my lord.
Full bench judgment.
Full bench judgment has been taken note of. 2008 one OLR your lordship is referring to. That has been taken note of, my lord, by the Honorable Court also. Your lordship, this was in the context of an interim order arising out of this kind of panchayat elections. Your lordship may kindly see. And there are at least 4 division bench decisions of this Honorable Court.
Petition is still pending. Petition is over.
Petition is pending or over?
Petition is over here.
Where?
Before the Honorable Single Judge. Election petition was dismissed. In appeal, the learned appellate court, the learned district judge, allowed it, saying that there has been infraction of Rule 51. Now it was carried to this Honorable Court. Honorable Single Judge has been pleased to reverse it, and that is how the writ appeal has been filed. Now, question with regard to maintainability also, your lordship says, this is not the only decision. There are 3 more division bench decisions of this Honorable Court post facto the full bench decision, saying that writ appeal is maintainable. And one more thing I beg to point out also, your lordship will find the writ petition is styled as one under.
No, that way, whatever it is.
Styling will be irrelevant.
Yeah.
I know, my lord. The purport is to be seen. But here there has been an interpretation and it has been held that it is maintainable. Simple.
Mr. Mishra, why did we put this question?
Yes.
Because the impugned order annexation 4.
Yeah.
This shows election miscase number 1 of 2022 arising out of election petition number 1 of 22 or what? This is a miscase and the later one has been
Man, it's the election miscase. That's what.
Only one.
One petition.
But see the order.
Your lordship is referring to
Annexation 4.
My lord, I'll just Annexure 4, your lord. 31. And that is one example. That's not different. Now there are other
Same matter. Same matter.
These are all panchayat matters.
No, number which brother.
No, it's the same matter. There is no dispute over that. Then one more judgment I beg to cite for your lordship. This is also another judgment. Where the first?
No, where is the answer about the maintainability?
Your lordship will kindly see that
I'm saying 2010 SEC online Orissa 86. That is Tarachand Majhi, Lalit Padhan.
Yes, that I am citing for your lordship. They are the question that was raised with regard to maintainability. Your lordship will kindly find.
Question I have read, that point is raised. But where is the answer?
The answer is there, man. Answer your lordship will kindly find.
Question is properly framed. Answer is not given.
Paragraph 5 itself.
Paragraph 5.
Yes. Objection was raised with regard to maintainability.
Writ of appeal is maintainable. You are right.
Not only that, these are other decisions also your lordship will find.
Anyway, one decision is sufficient. We need not weigh them. We need not count them either. One decision declares the law.
4 or 3 other authorities I also cited.
So on maintainability, we are with you. On substance.
Substance, my lord, one thing I have equated with these decisions, how a recounting is to be ordered, but that part of it I want to assist your lordship, because though I am equipped with those decisions, that is not organized, so I have to give it like I have organized, because this question your lordship was pleased to put me. So therefore I was ready with regard to the maintainability and I have brought all these decisions. With regard to the counting also, there are decisions, my lord, which I have, but I may be pardoned, my lord, it's not in a way to be
not well organized.
Paragraph wise, assist there may be little difficulty. I'll answer that also. Because there it has been held some kind of specifications which your lordship will find this application is wanting and the reasoning. Because if your lordship holds that this reasoning is sufficient vis-a-vis the rule 51(2)(3), then I have to bow down because that will become the law of land. I have nothing. I'm only assisting. My purpose of raising this point is the highest bench of this noble court, namely the division bench, will decide on this point whether this is a sufficient compliance of Rule 51. Those authorities, may only pray for deferment till tomorrow. I'll give it, but it's there.
But generally, we are not in the habit of...
give it, my lord, but it will be little difficult to... I have it with me, the recounting how it is to be ordered. But there has been many specifications spelled out. That your lordship may kindly pardon.
Call up petition.
I have to give it. Next.
Application.
Yes. Those authorities may be taken on record, my lord.
No, it will not do anything on installment basis. We are not happy with that.
I'll do that.
Sorry. Once we take up the case, we should complete whether this side or that side. For 15 minutes, if I go on, we are going on hearing on maintainability, which is a matter of 10 seconds.
Maintainability, my lord.
Next point you should have come. Anyway, now we will not waste much more time. Now call application.
Article 20, application 226 for 10
Yes. Yes.
This is a case against the order of the Central Law District Tribunal rejecting the prayer for regularization.
For regularization?
My lord.
How many years of service you have put in?
Petitioner initially engaged in 98, with some interruption. From
98 to which year? 28 years?
Some interruption, 2 days, 3 days. Subsequently in 2010, till date, my lord, he was regularly engaged in a month of 30 days, 31 days, 23 days, 24 days, like this. From 2010 till date, my lord.
Is it seasonal employment?
No, male driver, my lord. Male motor driver, my lord.
Male
and RMS, my lord. Railway mail service, my lord. And he was working since 98, and he was also engaged. He was given the identity card, and he was also engaged in COVID.
Identity card was given only for during the COVID for
no, prior to that. No, for COVID, he was given a permission to drive the vehicle from Kotak to Andhra, my lord. That was I have annexed, my lord. And also, he was given the identity card, my lord. That is
On regular basis, he has been taken.
Yes, my lord. He's now also continuing, my lord.
Even now he continues.
Yes, my lord.
Is it you appear for whom?
Yes, my lord.
That instruction I don't have money. But my lord, he has been engaged from 2020 for a period of 7 years with certain
breaks.
breaks, my lord.
What is the length of breaks?
My lord, sir,
You don't have a count?
my lord, sir, my reports are in the office, my sir. I beg apologies.
Whether we have one set of papers with us? If we have, share it with him.
My lord, that counter have not, inadvertently it has not been filed. I have served the copy.
Whether it was filed in the, whether it was before the CH earlier?
Before the CA.
Did you file there?
Yes, sir. For this Hon'Ble Court, I have prepared, but
I have received the
No,
counter.
whether it was filed there?
There also, my lord.
On that you have to file. Unless new things
You have a
emerge.
copy of that?
Well,
Those things are there.
Before Central Tribunal, they have filed. And also here they have filed the counter. I have received the copy.
You have received the copy.
Now, under which provision they will file counter here?
They have filed the counter.
Once it comes from a statutory tribunal. You cannot
Can
go
they
improving the
improve
case
it?
here.
No, no.
The battle lines are drawn
Well.
at the level of the tribunal itself.
Well,
Here, if there is any new development, you have to seek leave of the court to file the statement, counter, whatever name.
your lordship kindly turn to page 142.
No, but he does not have a file, na? Let him read and come back.
In my read petition that has been counter has been annexed.
True, but he does not have the copy which he wanted to go.
My lord, he has no counter.
Are you ready in the matter?
Where in this case?
My lordship, actually the matter, I've been going through it.
On the reopening day, you will argue. Reopening day. Then again, you should not
No,
take
I will
time.
not take any.
Yeah. All small matters. How many? So much here.
I will not take any.
Yes.
And the same covered matter by my lord, judgment, my lord.
So next.
21,
The petitioner here challenges the order judgment passed by the Central Administrative Tribunal. When the Central Administrative Tribunal, the opposite party had filed that application challenging the punishment and the consequential retirement. But the
Compulsory retirement.
No, not compulsory retirement. The normal date because of the wrong date of birth. He says that date of birth is 64. I said we said that it is 59. Very short facts, my lord. When the time he joined in 89-82.
Dispute is essentially about date of birth.
Date of birth, right.
Well, what was the date entered in the service register?
Service register, my lord, it was on 22-359. And he has himself submitted. I'm sorry.
One by one.
Sorry.
22-3-1959.
59.
In the service register, it was entered.
Yes, service register is also there.
Stated in the matriculation certificate.
Matriculation certificate, I'm confirmed. Matriculation certificate he came later on. But when he submitted.
Asking a question.
My lord, matriculation certificate is
mentioned in the matriculation.
64.
Full date?
That is that is
which is that judgment?
10-8-64.
10-8-64. That
10-8-1964.
64.
Did you make any application for change of date in the matriculation certificate?
No, my lord. My humble submission or kindly see for when he submitted his date of birth, he was not passed matriculation. When he joined the service, he had not passed matriculation. So when he joined the service, he submitted the school certificate, wherein he himself said the school certificate showed that 22-59 is the date of birth, and he has admitted before the inquiring officer also. Subsequently,
He has admitted.
The opposite party admitted in the so-called reply that yes, he has submitted the initial document at 23-59. That document he has admitted before the other. Subsequently, what happened, my lord? When at the age of 40, subsequently undated application, sometime in 87, he's filed requested for change of the date of birth.
When
basically
he entered service?
Entered service in 89-82. 89-82.
As
messenger.
And
And, he made application for change of date when?
In 87, undated application 87, but after matriculation certificate. September 87, he passed matriculation on the correspondence course. In the correspondence course, he passed matriculation. 1987, inquiry published 2/12/1987. After 2/12/1987. Sorry, my lord.
Dates for application of
2/12/1987. 2/12/1987, he submitted application for change of his date of birth. After he passed the matriculation or by correspondence course.
In the matriculation certificate, 10/8/1964 is mentioned.
10/8/1964, because the ballot will also
Why that is so mentioned? Why in
might be basing on his own date of birth, because all the school registers, it is shown as 22/359. The school certificate submitted by him, and subsequently when the vigilance inquired into the matter, vigilance also asked for the report from the
law is developed on that. So much argument is not necessary.
Sorry.
Whether rules provide for change of the date.
Yes, my lord, that page 210. Rule provides only 1 year.
1 year.
1 year. That your lordship judgment is also there. The rule provides 1 year.
But you applied on 2/12/1989. Though
87.
you were appointed in 18/9/1982.
He applied in 87.
It's worse case.
The your lordship judgment you also kindly see.
We have read that.
Yes, my lord.
We have read that. You are the employer.
I am the employer.
Who is for the employee?
Lord, I am.
What do you want to say?
But here the case is, charge sheet was issued against me for submission of that correction of date of birth is not the issue here, in this application. Charge sheet was given to me indicating that you have submitted a false certificate in 2019, Milord. On the basis of that, they have issued the charge sheet and they have proceeded against me. Inquiry was conducted and they called the vigilance department.
When were you retired?
Milord, I have to retire in 2024. And after this order of the Milord.
There should be full stop, comma, semicolon. Is it not? These are what they were taught to us in primary school. I do not know whether these things are taught in your state, but just we want to tell you, you have to go slow. You were appointed as a messenger on 18/9/1982. Correct. And in your SSLC certificate, you have mentioned 10/8/1964 to be your date of birth. No. Yes.
So 64 came
10/8/1964.
23.
No, that was entered in the service.
Yes.
Yes,
Subsequently, you have
Made the application.
in SSLC certificate, your date of birth is mentioned. There are two things now, as you rightly point out. One is whether that itself constitutes a misconduct is another thing. Perhaps case is on that line.
Yes.
Whether your date of birth right or wrong, that's a good time, test of time. From 18/9/1982.
Yes.
To 2/12/1989.
Yes.
You applied for change only in 2/12/1989. No. When did you apply?
That your lordship may kindly see the my lord's last order 17/3/2026. My lord's order, kindly see. In this order, in this case.
File was
kindly see.
directed for production of file, and file is also by officer has also come.
Then when they corrected it, that can be ascertained from the file. Therefore, your lordship called for the file.
No, when did you apply for changing?
But my humble submission, I have applied in 1982 itself, because corrected certificate I got in 1981. And I have wrongly, that certificate was submitted, another certificate. Immediately, I have submitted the corrected certificate that was corrected in 1982.
In the service register?
Yes, my lord. Then that was continued.
Think slowly. We need not be that emotional. The law is a sterile subject. We have to keep our emotions a bit alert. Yeah. Give that.
Well, by file list. Did that file is date certificate. My lord, must kindly see.
We have to see, ask them.
Page.
Page 1. That page is from the bottom, my lord.
It is from the bottom.
So it won't give the flag.
It is from the
Flag should give the flag.
flag. It is, all these flags are there, my lord. Initial flag is there. Yellow part is there. Flag it is.
Now it is a flag.
Flag is there. It is from the reverse because records are maintained like that.
National Aluminium Company. Yes. Is it a government company?
Yes, it's a government company. It's one of the Navaratna companies. First last ballot, page 1, that is about the ballot will page 3. Page 3, ballot. I'm sorry. Yeah.
Easy. Is he retired now?
Retired.
You are retired?
Yes, because
you want to take the disciplinary action also?
Disciplinary action was taken up. It actually he retired later. But this escaped the notice because the inquiry was being conducted about the false date of birth. He has shown the post date of birth. Yes, the allegation was that he had submitted a post certificate, and based on that allegation, the CBI directed the NALCO to conduct inquiry. Vigilance conducted inquiry. Vigilance also obtained. Sorry.
Again, you are making the same mistake which he has committed now. There is no pause.
Vigilance, no.
Part of the speech.
I'm sorry. I'm extremely sorry, madam. The vigilance, what happened? Vigilance conducted inquiry.
1 second. He retired on which date?
He retired finally on he was allowed to retire on 13 to 20. Though he was supposed to retire on 31/3/19, he was allowed to retire on 13 to 20. After the inquiry report was accepted by the
inquiry report said what?
Inquiry report said that the certificate basing on which the original certificate is post certificate. He has submitted the post certificate, and basing on the post certificate, inquiry report said that he is found guilty, and accordingly, the disciplinary authority accepted the report, and since that he has already overstayed his service, so they allowed him to retire on 13 to 20 with the specific that it will not be the amount which he has received will not be recovered. That was the order.
Is it a punitive order? Is it a punishment order?
The punishment order has also been there. Punishment has also been there. Punishment is only censured because they had already attained the age of retirement. So that's the only censure punishment was also there.
After retirement, can you administer censure?
Because as per the amended as per the rule of service, even after retirement, proceeding can continue like any other.
No, according to you, his retirement will be in 2019.
He was initiated, disciplinary proceeding was initiated prior to his retirement.
Prior to retirement.
In 2018.
6 years. 1959.
And if we
what is your qualification?
Diploma.
Diploma in aeronautical engineering.
That diploma, I have given that
diploma in diplomacy. You have to tell no, otherwise we have to judge you. If you are a farmer coming from rural background, who always would roam with the cow, etc., our approach will be different. If you have spent time in the campus of the university, our approach will be different. That's how Apex Court has said. Even in the way that is
qualified bachelor in arts, bachelor in arts, my lord. 1960.
1959. So then your progress. Declaration. Now you have been retired.
My lord.
You have been retired.
August 2024 is the normal date as per my ballot of document.
Kindly see the originals in your handwriting.
My lord.
Kindly see these documents. Kindly show it. Every document my brother has shown.
My lord.
In every document, right from the beginning, you have said that 22/3/1959 is your date of birth. Kindly see how many documents. And one document, declaration, which contains your entire horoscope, is attested by a lecturer. It is in your handwriting.
Miller, that is 1982, Miller.
Yes.
And
just kindly see, when judge, when court requests.
Yes, Miller. I'm looking to that, Miller. 1982, Miller.
Come to your biodata dated 24/9/1982. It is biodata, not just biodata. And come to your declaration dated 13/9/1982.
Mr. Oja, not this side. It is only in the bottom side, not in this side. Both the documents are in the bottom side.
Assistant.
Last but suppose.
Assistant 7.
13. It is filled up by your handwriting. They are your letters. And you are a graduate.
Yes, sir.
You
By
take
that
diploma.
Lord, by that time, I was not the graduate. I was only eight pass, my lord. Then after taking permission from the department,
I studied and completed graduate.
Yes, my lord. And my
did your graduation on which date?
Graduation, my lord. That is
When were you issued graduation certificate? When the graduation day was held, and when were you issued the graduation certificate? What is the date mentioned in that?
1998.
You completed your graduation.
1998.
That's a BA.
Milord.
Bachelor of Arts.
Yes, Milord. 1998.
Huh?
1998.
Which is that certificate you are reading and telling us?
But that is, your lordship will see the counter. In this case also, I have filed one counter.
Not counter. Where is the certificate? What is the date of your birth mentioned in that certificate?
64, Milord.
Huh?
That was indicated. But that document they have not annexed that.
How they will have a document?
OA copy they have to annex, Milord. They have not annexed that OA copy. That document, Milord.
Mr. Mishra,
My lord.
he has worked all these years. He joined the service on in 1982. From 82 to 2000,
20, February 20, 13
how many
to
years
20.
he has worked?
Sorry?
How many years he has worked?
Yes, that not in
1982.
82. 18 years, and then that will be
13 February 2020.
Yes, 13 February.
20 years. Right. He is deciding to talk to the this is what we and 2 years.
And
28 years he has put in service. Was there any other complaint than the one which you have now held?
No, that no. At least I don't have that instruction, and I don't know that. No other proceeding earlier.
No other proceedings. We are suggesting is because courts have taken the view. Those who have put in long number of years of service, after retirement, they should be left to the evening of their life untroubled. Courts have said that.
But
Instead of now, he has retired on 13 to 2020.
yes.
We are just thinking aloud. We are not even suggesting.
Yes.
It is, we are thinking, you are hearing our voice,
Yes.
that's all. We are not suggesting.
Well.
We don't know when we give dictation, what way the things will go. We really do not know. Now, we are just asking you, can you put an end, put a quietus to this entire episode?
Yeah. But censure will be, the censure only, censure is there. There is no other punishment. There is no other punishment.
Censure will not give because censure has to be given in the morning. It comes to an end on the sunset. That's the law.
And
After retirement, you could not.
after that, he can, because we have not recovered any amount from him, and he has got that. There is no pension in NALCO. So the other service benefits he has already got.
What is left then? What is the proceed against you?
Retirement has been made retrospectively.
Yes, Mr.
And
Officer,
what has happened, my
What
lord?
is left?
No, my lord.
What is left for you?
My lord, my humble submission, that document which your lordship wanted to know that when I made the application for correction of the date of birth, that document is not available.
Yes, it is there. It is there. It is
That
there.
document your lordship wanted to
there.
particularly when I made the application. No, my lord, your lordship may kindly see. For a moment, kindly see page 215, my lord.
Your own, the other documents are in your own writing.
My lord.
Now we are making some favorable
Yes,
observation
that
to
is
you
not-
because your client has retired.
My lord.
After retirement, he should not be in the court corridor.
Right.
That's our object.
No, my lord, my
Only to put an end to all this. If you argue, you are entitled to argue, but order may go. Think about that, your advocacy.
Then they have already given me the retirement in 2020. 2020.
Put an end to all this.
Now, my lord, my humble submission,
That will be fair.
document,
It is very fair.
my lord, They put the allegation against me. I have submitted the 4 certificate.
No, that will put an end to that.
My humble submission. That is the only reason for which they have given me the compulsory retirement.
Going back. Go back. Now whatever date
service, I was left.
No, you are
service. For a moment, your lordship may kindly see. Your lordship will put 215 page 215. Your lordship may kindly see. After the Learned Tribunal's order, they have implemented the Learned Tribunal. Moment kindly. Kindly see.
with threat of contempt.
No, not contempt. Contempt files much after Milord. And your lordship may kindly see implementation of order passed in such and such. They have taken the decision.
That has been withdrawn.
Page 215. Your lordship may kindly Milord.
It has been
Then
next page it has been withdrawn.
Your lordship, they imposed that I will not claim the salary for that period. I have also agreed. Next day I have joined Milord. And now because of that vigilance raised some query, therefore they have filed this writ petition. And only allegation that I have submitted the 4 certificates.
That has been proved.
Headmaster of the school, he has given in writing. No, this is the certificate I have issued.
Have you filed affidavit in terms of this order?
Yes, Milord.
Very good.
But that is at the...
Mr. Mishra.
My lord, kindly see next page. Yes, my lord, I have seen that.
215.
Yes, I have seen that. And page 216, my lord. Because the page 216. Next page.
This is after how many years?
No, only 1 month after.
Why that order?
1 month after 29. 1 month, not 1 month, 4 days after. 4 days after. 4 days after, it has been directly implementation of the order. It has been penned by letter dated so the above such issued in compliance with direction of this CMD for implementation of the order of the CAT, and the copies of letter were sent to CBO Functional Director for information. Scheduled letter number so. These certain issues were taking Patrak Patnaik into employment which need to examine. Pending examination of the issues, jurist director communication ready. Kept in abeyance until further.
Where have you withdrawn that letter? You have kept it in suspension.
Yes, kept in suspension.
In abeyance. Abeyance is interpreted by the apex court.
Yes.
You have not withdrawn this letter.
Yes.
You have kept it in abeyance.
Yes.
With the judgment which interpreted the word abeyance. There are High Court judgments. And ask our librarian to bring words and phrases by Surendra Malik. Supreme Court on words and phrases. You have not withdrawn.
No, it has not been withdrawn.
It
has been kept in abeyance.
It was issued by the CMD. Highest authority has issued that.
The highest authority has issued that because that is me, but thereafter they took a decision to challenge the judgment before the Hon'Ble High Court.
No.
And that is the reason why.
You did not say all that. You have put A, B, C, D conditions.
Yes.
Those conditions he has complied with. Take out the word abeyance. And you have not withdrawn the letter. It is kept in abeyance. Keeping it in suspension.
Yes, that is true. That is true, my lord. But the thing is that the disciplinary proceeding matter, my lord, your lordship will find is categorically proved that, my lord.
Rightly or wrongly, your managing director, it is not that some joint director, some FDC, some regional director taking that issue. Under your standing orders, managing director happens to be the ultimate authority subject to control of the directors. Board of directors.
Board of directors.
Who is this director?
Director Richard.
What is his power?
Director Richard will like to see.
Where is his power?
Director Richard is the best power in the HR matter.
Your rules, you have not argued.
Rules. I don't have the copy of the rules right now. But the refuse to take.
Managing director under company law, Avtar Singh writes, managing director is the conscience keeper of the company.
Yes, that is true. That is true.
He is the conscience keeper of the company.
That is true.
Therefore, he has taken the decision in the best interest of the employee and the employment. He has put ABCD conditions, which he has complied with. Now, all of a sudden, waking up from the slumber and then saying that we are keeping a jurist. What that jurist is? Palkiwala.
Because what happened at the...
Where is the name of that jurist? Who is that jurist who has advised it?
My lord,
See the opinion.
actually, that was a complaint objected to by the chief vigilance officer. Chief vigilance officer. The chief vigilance officer is the independent authority.
No, kindly see that. You have said eminent jurist. Who is that eminent jurist? Where from you?
Opinion from the...
No, who is that eminent jurist? We have to know.
No, the petition has been filed obtaining opinion from the Attorney General, I think. Attorney General. Attorney General. Attorney General, from the opinion of the Attorney General, petition has been filed.
Sure, that. Where you are adding Attorney General word. Petition is different. This opinion, you are mentioning eminent.
That we have stated in our petition, we have stated so. The copy of the report, opinion I have not filed, but in the petition we have stated that obtaining opinion of the Attorney General, petition has been filed.
Filing of petition is another thing. In PSUs, very important matters in which is that Jain Hawala case, where Apex Court said generally when these complex issues arise, opinion of the Attorney General should be sought for. Solicitor General should be sought for. There are such observations. The Vineet Narayan versus Union of India. There are such observations. But how can this be? You have not even withdrawn that letter. That letter remains active. It is not a case of withdrawal. It is keeping in abeyance.
It is keeping in
abeyance. Which is that abeyance? How do you word abeyance? Good abeyance, which is that judgment of the which I put abeyance. That
because it has been proved that he has filed a post certificate that has been proved by the email. That record also will clearly show that it has been proved.
Not that. You are an employee.
Yes,
I get it. Entity under Article 12.
Yes, sir.
Once a state entity, there is a difference between East India Company and state entity under Article 12. Once, if the managing director of a company takes a decision for rescinding it, there should be extraordinary reason. And what is the power of the director to rescind the order of the managing director? Where is the power?
That rule I will have to produce.
If the board were to pass a resolution, perhaps some other
the rule will have to. I will have to produce the rule because to show the powers of the director.
Not at this stage. Not at this stage. Bajranga.
Because
state of Madhya Pradesh. Yes, where is which paragraph? Paragraph 24.
If you also will permit me to see 3-4 lines, page 95. No. Because by that our right to challenge the judgment is already there with us, my lord. We have
compliance system, no. And you said there was threat of contempt. Where was the contempt?
No, contempt, by that time, contempt was not there. Contempt was not there. But the threat of contempt, because threat of contempt is because it is that if we do not comply, then the contempt will be filed. That is
Where is that?
No, that is not there in the but that is there in the background of the case. That is that is
in the latest abeyance order. Let us see how it is texted.
216.
One judgment of Apex Court which interpreted abeyance. There are at least 2 judgments of the 2 high courts. Take out that judgment.
Permit to page 3-4 lines, my lord, page 95.
No problem. 10 lines you can see.
The charge-sheeted employee has, page 95, my lord. Charge-sheeted employee has accepted submission of both the school leaving certificate and perusal of prosecution evidence. It surfaces that it is a fair probability to study class 6 at an age of 6 years, considering the date of birth at 10/8/64. Mentioned in the duplicate transfer certificate. Affidavit for change of date to which surfaced during inquiry proceeding cannot be fit case as defense evidence to prove that the duplicate school having certificate is not forced. And this certificate is posted and not forwarded. And he himself, when the question was put to him, he said that he gave the example of Swami Vivekananda. Page 92. In defense argument by giving example of Swami Vivekananda and considering the education background of the C, not applicable. The conduct has to be seen, my lord, also. The opposite party's conduct has to be also seen.
Your conduct also.
Yes, that is true. Well, conduct of both parties. Conduct of both parties. That is your. Well, you also will deliver justice. You also will look at the conduct of both parties. That I am conscious of it, my lord.
No, we do not agree with your proposition. Conduct of state entity is, the standard is high.
Yes.
Conduct of citizen, standard is low. State entity has to conduct itself as a model employer.
Yes.
2013, that famous Bhupendra Hazarika versus State of Assam.
Prior to that also, much earlier. The concept of regularization came, there only the Lordship, Honorable Supreme Court said that the employer has to be...
Nothing.
Indeed.
He reported for duty back on which date?
That is on 4/3/2024. That is at page 17. Page 17 of my counter file in this case. Along with the affidavit,
4/3 itself it was withdrawn. 4th March itself it was withdrawn. I mean, it was kept in abeyance.
No, you are not withdrawn that.
No, I'm sorry. I'm sorry, my lord. It was not withdrawn. It was kept in abeyance on 4th March 24. 4th March 24. So he has not, pursuant to this, he has not joined. Pursuant to this order, this communication has not joined.
He did not join?
but they have received but did not allow me to join. They received that letter, my joining report, with affidavit, but they did not allow me to join and issued this kept in abeyance order immediately.
What the tribunal said?
Tribunal
has that order of punishment, my lord, and directed to allow me to continue in the normal date of retirement in August 31st August 2024, my lord. Taking into account that my certificate and school authority letter where they have specifically indicated that the 1959 was corrected subsequently in the school register and that has been given to him.
Tribunal, my lord, tribunal went on a proceeding that there was a preliminary inquiry. There was no preliminary inquiry. Basic on that, the preliminary inquiry report has to be given on all the basic on that and also went to oral evidence, which is not permitted to do.
Can you be seated? The management of the employer company is knocking at the doors of writ court for assailing the Cuttack Central Administrative Tribunal's order dated 19/10/2023, whereby OP employees OA number 326 of 2021 having been favored, he has been granted relief as under. Go to relief para. Para 15. Next. It is para 15, page 197, 197. The after service of notice, the OP employee having entered appearance through his counsel resists the petition, making submission in justification of the impugned order of the tribunal and the regions on which it has been structured. First, learned counsel representing the employee draws our attention to the letter of the managing director's letter dated. Sit down and answer. Managing director's letter.
215 page. 215 page.
That is a director HR's letter. 215.
Director HR. Director HR. Director HR's HR directors. Letter dated
29th February.
29 February 2024.
Yes.
Wherein a clear-cut intent and conduct is demonstrated for accepting the verdict of the tribunal subject to certain conditions which the employee has complied with by filing the necessary affidavits. First one. Read the sentence. On the part of the management, but demonstrated the acceptance of verdict of the tribunal. So, affidavit. First one. He further contends that once an order is complied with voluntarily and knowledgeably by the management, subsequent turning around or laying a challenge thereto is ordinarily impermissible, subject to exceptions. First. Next. Having heard learned counsel appearing for the party and having perused the petition papers, we decline indulgence in the matter for the following reasons. 1. It is not in dispute before us that the company, petitioner company, is an entity under Article 12 of the Constitution of India in the light of Apex Court decision in Raman Dayaram Shetty versus International Airport Authority Limited. 80 or 81 Supreme Court? 81 Supreme Court. First, it is relevant to mention that an Article 12 entity has to conduct itself as a model employer, while Bhupen Hazarika versus State of Assam, 2013, as contradistinguished from East India Company of the bygone era. First, after the impugned order was handed by the tribunal, none other than the director human resources into bracket, took a conscious decision to implement the same, subject to certain terms and conditions, which the OP employee has indisputably complied with. First, it is not the case of the petitioners that the director HR was incompetent to take decision of the kind. Nor it is their case that the decision of the director is prejudicial to the interest of the company itself. First off, not even nearby pleadings are taken up either before this court. First off. Next paragraph. The vehement submission of learned senior advocate Mr. Mishra that even before the ink of letter dated 29 February 2024 had dried up, another letter dated 4/3/2024 was shooted from the side of the management, keeping the said letter in abeyance, would not come to his aid, inasmuch as the subsequent letter, by its text and context, has kept the earlier letter only in abeyance. First off, thus, it is not a case of rescinding the earlier letter at all. First off, it hardly needs to be stated that there is a difference, ACA, between keeping a letter in abeyance and rescinding the letter, which even a blind man can see. First, in the former, the letter in law would continue, unlike in the later. First off, even to this day, we are not shown one single document from the side of the petitioners that subsequent to issuance of abeyance letter, the letter dated 29 February 2024 has been withdrawn or cancelled. First off, where action of the management, where proposal of the management is accepted by the workman, our labor jurisprudence does not permit such a management to blow hot and cold, as is being done in the case at hand, more particularly when petitioner, the employee, wide letter dated 4/3/2024, a copy whereof avails at annexure R/1, had informed the director HR about the compliance of the order dated 19/10/2023 entered by the tribunal, which is now put in challenge subsequently. First off, the said letter also mentions about HR Director's letter dated 29 February 2024, a copy thereof being annexed, enclosed to the said letter. First off, accepting the contention that the tribunal's order is fraught with infirmity would be denying fairness and justice due to OP employee, and that the rate court cannot do in the light of the directive principles of state policy enshrined in Article 40, which is that fair conditions of the state should treat the workmen with fairness, etc. Which is that? Sorry, 12. Next paragraph. Mr. Mishra's contention that the OP employee was born on 22/3/1959 and therefore she ought to have attained the age of retirement / superannuation on 31/3/2019 is a bit difficult to countenance, in as much as subsequently the date of birth of employee has been rectified to be 10/8/1964.
It has not been rectified by the management at all.
No, that is not in contention. 10/8/1964. What you have written? As rectified as so and so, this contention need not be examined by us because of the conduct of the management, which would attract the doctrine of promissory estoppel in the light of Indo-Afghan agencies versus so and so. First, in the next part, in the above circumstances, this petition fails, courts having been made easy.
But the tribunal is directed for payment of wages also. That will also. Tribunal is directed for payment of wages also.
Given up
that part will also kindly note it.
That you have to give up. You have already given up in your affidavit. 1 second. Next one more. All the above being said, learned counsel Mr. Mishra is right in telling us that the direction of the tribunal to pay the back wages needs to be liquidated in view of the specific undertaking given by the employee through the affidavit in terms of letter dated 29 February 2024. First up. Next, in the above circumstances and with the above observations, this petition is disposed of. Because you undertake. You cannot also blow on
But other benefits are very mentioned.
In terms of that, we have said. That's all. Yes. Yes, sir. Yes, Mr. Mishra, how are you? How is your health now?
Yes.
You're all right.
Another memo I'm finding. That shows that they are getting the temporary sweeping charges, vouchers. That is the thing, not on wages. That voucher also, which I've also annexed, they're getting temporary sweeping charges. Not on NMRT.
Foundational facts you have to submit. We don't remember. You just refresh our memory.
I can tell you, well, we will tell it in my humble because my learned senior will be opposing me. So if he will place the facts, your lordship will be convinced.
The only thing is, you should not file documents which I cannot answer unless I verify it. Therefore, he is trying to file certain documents now. You can't file a memo of documents relating to the
Copy and so.
No, that's exactly say.
All right, you show it to your client. We'll call this matter day after.
I have given the documents. One voucher has been given.
When you have given?
Just now.
The other vouchers are there, but this is a running voucher.
You give that document when?
Today I gave him I served a copy.
Should he not show it to his client? See, this is produced by the opposite lawyer.
He's relying on you.
That's one.
No, I'll be.
If you do not rely, then we will not.
I will rely upon it.
Then you have to give.
It is there in 8 April.
It's already there.
There. Part of the documents are there.
Then no time will be granted.
It is there.
It is there.
Why you have filed then?
No, that's all right. We will ignore this.
That is another month.
We cannot take disciplinary action for producing the same document again.
Not the same document. Not the same.
No, not the same document.
It's there. It's there.
It is there.
Kindly show it to learned counsel.
1310 is a vouchers but a DI, temporary sweeping charge.
Today you have filed. Is it the same thing? Yes.
Then, not the same thing. This relates to another month. Your lordship will see these are
running voucher.
5051 is the temporary sweeping vouchers they are giving. That temporary sweeping charges for another month I have just given.
You take that back, and otherwise matter has to be urgent. Or if you say, then we'll have it next week so that he will face that. He will put it to his client and come back with his.
Then your lordship may return it back. Let my learned because the fact remains. Well, just the background is.
Yes, sir. What are the foundational facts?
The foundation of the fact, your lordship had just to recollect, since 94-95. We were appointed on daily wages basis, these two scheduled caste persons.
Appointment?
In the year 94-95.
All they are scheduled caste persons?
These two persons.
How many are there?
Two persons are there.
So both are scheduled caste
persons? Both are scheduled caste persons. They were engaged as temporary.
1 second. Engaged as?
They were engaged as sweepers, that is submenial staff, casual staff. Submenial staff, class 4. Under the bank, submenial staff. They are called submenial staff, but they were initially engaged on wages basis, daily wage basis. And sweepers, class 4 employees.
When it was?
In the year 1994. One person, another person in the year 95. Your lordship had already
Who is 94? Who is 95?
The first petitioner is 94, Mayadhar Naik.
Petitioner 1.
Petitioner 1. And the other one is in 95. Thereafter, my lords, after continuing for 5 years, we moved a writ petition for regularization of our services.
That WP number?
That WPC number I have already given.
Where my notes?
Yes. That may be your.
Where are my notes? That WP number?
13193, possession number 13193 of 1999.
OJC number. I remember written something.
Yes.
Scribbling something. This is.
Writ appeal number 1310, I have given those two judgments are there in the regularization matter.
1310.
Your Lordship may have a glance at page number for your Lordship's convenience.
Slowly. In that, it was decided on 5/12/2008. Correct?
My lord. 5/12/2008.
What it said?
In view of our order dated 24/7/2007, passed in WPC number 8906 of 2007, no further order is required to be passed in this case. We dispose of the writ application in terms of our order dated 24/7/2007, passed in the aforesaid writ application. We make it
slowly. Which writ application?
That is OJC number 13193 of 1999.
Where is that order? Earlier order.
That order is earlier order where two writ applications were filed. One is 896, WPC 8906 of 2007. That is, your Lordship, I kindly have a glance at, if your Lordship, I have given that annexed, the document has been annexed in writ appeal number 1310, the other writ appeal, those two orders. I have given a free copy. I have given a copy on the earlier occasion. Probably that is not the memo of documents is there, but that read.
No. 5/12/2008 is the order.
Your Lordship, I kindly have a glance at page number 81 of that earlier,
Kindly understand us. Kindly be kind to us. See, the order dated 5/12/2008, it disposed of OJC 13193 of 1999. Am I correct?
My lord.
That said, we had made an order on 24/7. 24/7/2007 in WPC.
(8906).
8906 of 2007.
Disposed of on
24/7/2007.
Let us see that order. Let us see that order. Show that.
My lord, the distinction is that the first writ was filed.
Let us see the order.
Yes, 820. That is page 8. Your Lordship is there.
Yes, it is with us.
Yes,
What
hard learned
petition?
counsel for the petitioners, the grievance of the petitioners. Lordship,
Yes,
what-
that's the one.
in this writ application is that even though they were
Consider petitioners in the event they are going to make any appointment
to the
post of sweeper, looking at the length of engagement and the service rendered by the petitioner under the ban.
Well, so two writ applications were filed. One was for regularization of our services after 5 years. That is OJC number 13193 of 99. That writ was kept pending. And in between, my lords, what happened after in the year 2007,
Apprehending their disengagement, you filed another.
I filed another writ application seeking that they were going to fill up the post by way of outsourcing instead of giving us appointment, regular appointment, taking into our note of services. So we may be appointed in accordance with law. So therefore, right. And both the matters were heard in presence of the parties, my lords. So after that writ application was disposed of, this OJC number 13193 was disposed of. In that context, can I
Please say that to make it clear that the case of the petitioner shall be considered for regularization.
for regularization?
No, the petitioner shall be paid remuneration as applicable under
Yes.
the minimum.
Why that? Then the question now arises, my lord.
Which is that one. That is disposed of on OJC what is OJC 1
Oh, this one, this both of later, then this one. After this, first this both. 522,000. This one. Oh, no. Floor to continue to work as such and shall not be substituted by any fresh hand. Petitioner shall be paid remuneration as applicable under the Minimum Wages Act.
Yes, this is one aspect. The aspect is that, my lords, it was decided that they will consider my case for regularization. So that issue attained finality. Since 5/12/2008, so far as regularization issue is concerned. The second issue was...
The first issue is?
This REIT was filed for regularization of our services. That we are put in 5 years of services at that point of time, taking into Pyara Singh's judgment, and that time what was the law?
Where is the order?
This 5/12/2008.
Where it mentioned? Read the operative portion.
We make it clear that the case of the petitioner shall be considered for regularization if any vacancy arises. If any vacancy arises in future, so long as the work is available, the petitioner shall be allowed to work as such and shall not be substituted by any fresh hand. The reason being, well, just the catch is there that there were 2 sanctioned posts. That is, I have given that in the OJC number 13193, the counter affidavit filed by the bank. They have admitted that there are 2 sanctioned posts in the government treasury branch. One person was continuing as a sweeper, another person was substituted hand from Puri. He was posted there. Those 2 posts fell vacant, and thereafter we continued against those sanctioned posts.
Where is that admission?
That admission, Your Lordship, may kindly have a glance at the affidavit filed in OJC number 13193. I filed a memo. In person to memo, I have given that before the court. This counter affidavit. This is memo of citation and one counter affidavit. Counter affidavit filed in OJC number 13193 of 1999. Your Lordship, it is there on records.
Petitioners are members of scheduled caste. First petitioner joined in the year 1994, and the second petitioner in the year 1995 as a submenial workers, that is sweepers. First one. They had moved WP 8906 of 2007 seeking regularization of their services. No, in 131. In this, what they have said, this is they were going to be decentralized, so this would continue. No press would be taken. Seeking whatever for a direction, for continuing them in service. First time. Any interim order was passed there?
There was an interim order was passed.
When it was made?
Well, that OJC record would reveal it. I have got that.
Do you have copy of the order?
Copy of that order.
Are you sure that any interim order was made?
Yes, yes.
There was a interim order.
10/12/99.
On 10/12/1999, there was an interim direction to continue the...
Date I'm confirming. Just 1 second.
Continue the petitioners in employment pending deleted.
So that was, he filed on 12827 you're still referring to?
Where?
No.
13193 of 1999.
13192.
193.
Interim order was there.
Interim order to continue.
No, interim order not to
Terminate.
Without leave of the court.
There was an interim order not to terminate services of the petitioners without leave of the court. The first one. Next point. During the pendency of OJC, petitioners filed WPC 8906 of 2007, which came to be disposed of by an order dated 24/7/2007, directing the
that is not
OPs to consider
for the certified copy.
the case of petitioners
Maybe, excuse me, the certified copy I have that
for appointment.
if there is one.
No, we have that.
That certified copy. The certified copy.
No,
This is different from
The interim order which your lordship asked in
No,
99,
that-
they have said if there is work, there should not be retrenched. That is not it was a conditional interim order. So what my learned, not to retrench is wrong. That is different. That will come in the bar of Umar Davis. They want to cite in that light, the 10 years with the continuous service. Okay.
You have written now? Appointment to the posts of sweeper, keeping in mind the length of their engagement and service rendered by them. In view of this order, the OJC 13193 of 1999 also came to be disposed of.
5/12/2008.
On 5/12/2008, that petitioners be considered for regularization if any vacancy should arise, if is not necessary, should any vacancy arise in future, and that they will be continued in service, paying remuneration as per the MW Act. Yes, sir. This much we have understood now.
Yes,
No,
my
there,
lord.
another line is there. If your lordship looks at the order dated 5/12/2008, the second paragraph, I think, second or third, it says, we dispose of in the light of the order dated 24/7/2007,
Correct.
passed in WPC 8906 of 2007.
Yes, we have said.
Now, your lordship, the matter was both the parties appeared and it was.
We want to know whether minimum wages are being paid or not.
My lord, the minimum wages were not paid.
Not paid.
Were not paid. So therefore, here, my lord, just the difference is that we are seeking a temporary pay. We were continuing.
We are asking one by one. We go.
What?
Minimum wages.
Was it not paid?
How was paid to you?
That was paid. We were paid daily wages, which was less than the minimum wages during that period of time. Now, your lordship may see the areas. That is why last occasion your lordship had marked that page. Your lordship may kindly have a glance at page number 160. 160 of my writ petition or writ appeal, page number 160. That's why your lordship put a question with regard to the stepmotherly treatment meted out to them. That your lordship may kindly have a glance at page number 160. Your lordship got it?
Or that tabular.
My lord, yes. That is page 160. This 28,875 was paid arrears on 12th February 2009 after your lordship's order in the WPC number, OJC number 13193. So this was the
pursuant to this order, there were two persons.
2 persons.
For one person, how much? To another, how much?
28,875 arrears for all those years of working. From 95 to...
Petitioner 1 was handed a sum of rupees
28,875.
This is check.
This is a check issued by the bank.
Which bank?
State Bank of India.
An SBI check for rupees 28,875.42
on 12th February 2009.
On 12th February 2009. As being the arrears or differential of arrears?
Differential. Differential of minimum.
Differential of arrears because of adoption of minimum wage schedule.
And page 161 is for petition number 1. That because 29,162 because he was engaged earlier than the
of petitioner number 2.
1. My other 9.
This is 2.
This is 2.
Number 1. You make it 2. In respect of petitioner number 1, another check for rupees 29,162.80 evenly dated was handed for the same purpose.
Same purpose.
Then
because he was appointed earlier. That is why the difference of
little more amount he will get.
Little more amount he got. During this period, what happened, my lords? They took, there are actually 2 sets of employees in the bank. One is a regular employee, class 4 employee. One are temporary employees. Those who have worked for more than 240 days of service, they have put in the bank in a year. And continuously they have worked for 2 years. They will get a temporary employee status. Temporary employee, they will be treated as temporary employee. They will be allowed temporary pay. So we were initially appointed on daily wages, but we perfected our right as a temporary employee after 2 years of continuous service.
Where is that document?
Well, that document I have not given. My service record. My service service record. Your lordship query is that
your clients became temporary employees. Or they obtained.
Yes, your lordship may kindly see the vouchers given to me. Page 51, the pay slip vouchers, because we are class 4 employees, they don't issue any letters to us. Our vouchers will speak. Page 50, your lordship may kindly see. Page 50.
What is this document?
Page 50, your lordship will see.
Through which they have been paid in cash.
They have paid in
against revenue stamp.
Yes. Temporary sweeping charges. Your lordship got it?
Sweeping charges.
Yes, that is our monthly payment. It was not on wages basis any further. This is issued in the year October 2012. That is the secondary. This 2012. So we were paid consolidated temporary sweeping charges. And the documents to show that we were also temporary, but we were not getting the benefit. One such document was issued by the AGM, which page number 113. Because these are the things when during the COVID period, risking our lives, we were not permitted to go outside during the patrolling time. So your lordship may kindly have a glance at page number 113, the certificate issued to me by the AGM of State Bank of India.
Then another petitioner?
Another petitioner, my lords, 115. 115, your lordship may kindly have a glance.
Next point. The management wide letters dated 23/3/2020 issued during COVID-19 pandemic treated the petitioners as temporary sweepers. First one. See page numbers 114 and 115.
16.
So by treating them as temporary sweepers, what follows?
The follows is, my lords, that we were not paid the bonus. Suddenly they stopped, for which I filed this second writ, that is, which is before your lordship, which you are adjudicating, your lordship now, temporary pay. That we are not getting our temporary pay. The bonus was stopped. They harassed us.
Where is your
lordship?
Prayer.
Your lordship may kindly see page 127, where they gave us our bonus. That bonus.
Now let us see the prayer.
Page 127. Prayer of the writ petition, my lord.
The writ petition is 2012.
2012.
24692.
My lord. This is what we have come up against. One is this and other is regularization. This we have sought for. This is all our entire lifespan we have given. For that we are here, for that areas, for that period.
Let us see the prayer.
The petitioner therefore prays, your lordship may be graciously pleased to admit the opposite shall not provide.
They are appellants. They are the appellants now, petitioners.
They are the petitioners now, appellants now, before your lords.
Learned single judge said what?
Just in one paragraph, he said that what was a prayer, he did not adjudicate it. He said, since they are not temporary employees, they are not entitled for the benefit. One single paragraph. That composite writ appeal direction, only one paragraph. That is not adjudicated also. It has not been adjudicated. And I will not submit anything beyond the record, my lords. That is nothing beyond the records.
Petitioners filed appellants filed WP number 24692 of 2012 for grant of temporary pay for releasing bonus. And for releasing the bonus. First. Learned single, where is the order of the single judge?
Annexure 1. Your lordship may kindly have a glance at the findings portion, because the rest all are submissions and counter submissions and other things. The claim number 10. Number 10. That is the submission.
What was
number 19, paragraph page 34, your lordship may kindly have a glance.
All right. What was WPC 15989 of 2020? Two petitioners.
That these two petitioners filed a case for regularization again. That was disposed of with a direction. This is under the challenge, subject matter of challenge before your lordship.
Both the petitions were heard
together. That was a period for regularization in 2020 we filed, because after continuing for more than 25 years around, we were not regularized in service. So we said that, your lordship said that we will...
There is no breakup in service.
There is no breakup in service. That is admitted fact. From the records also, they continued.
You show that they were working against vacancies in the sanctioned posts.
But that, your lordship may kindly have a glance at the counter affidavit. There are 2 vacant posts. They said we continued. Kindly have a glance at the counter affidavit given in OJC number 13193, which has been suppressed now.
Show that.
That is paragraph, page 41, paragraph 17. Why I am saying suppressed, my lords? They are telling, they have raised a stand that we are not continuing in a sanctioned post. That is why the reason apprehension.
Where have they admitted sanctioned posts?
Your Lordship, I have a kindly glance at paragraph 17 of my memo of citation and one counter affidavit. Memo citation and one counter affidavit. That is also scanned copy. ସେଇଟା ଗୋଟେ ଆଉ ଗୋଟେ ମେମୋ ଦିଟା ଦିଆହେଇଛି ଫାଇଲ
Also incorrect statement.
Paragraph page 41, Your Lordship, I have a glance.
Already filled up. The last one being 1699. You see, or child.
Yes.
Permanent paper Puri bank on surplus has been transferred to government treasury bank and joined in the same post branch. There does not exist any vacant post. There do not exist.
Anyway, that time that was a stand in 1999. That is why Your Lordship directed in the operative portion that that sanction post is filled up. So in case any vacancies arises, there's a case that shall be considered for regular.
Now, where are the vacancies?
That vacancy occurred because this person died. One of them died and the other person retired in 2015. These two posts which are filled up. One person died, one Mukhi came. That also is there.
Two vacancies
the regular
to which regular appointments were made. First off, one of them died. When he died?
He died in around in 99. I think just.
No, it cannot be 99 because he was appointed on 6/10/1999.
6/10/1999. This is paragraph 5, page 46. Their counter affidavit. Also, they have stated.
One of them died, and the other attained age of superannuation.
Raj Kishore Mukhi was posted. He expired, and one Rabindra Gochayat joined.
When
that is page 45. He died somewhere in the year 99 or 99 only. He died.
When the other person retired, retirement happened.
As I have reliably learned, it is in the year 2015. Probably one person.
Ask your client if anybody is here.
That in page 46, Your Lordship may have a glance. That is their counter affidavit, that memo. They have also stated.
After reading that only we ask the question.
Paragraph 45.
Paragraph 45.
Sorry, paragraph 5 end portion. In the meantime, 2 permanent sweepers have been posted in the branch. Your Lordship,
no, they say they were permanently appointed.
Permanently, those 2 persons were posted. One on transfer.
Retirement happened when?
One retired in 2015, the other expired, and the post fell vacant.
Death in?
Date in the year, I think I filed in 1999.
It cannot be.
1999.
Appointment itself is in October 1999.
No,
they have to dig the grave and bring.
No. In R.K. Mukhi, R. Gochayat joined in the year on the date 6/10/99. In addition to the permanent sweeper of the branch, namely R.K. Mukhi, one person was continuing. Then another in the transfer vacancy, they transferred another surplus staff, they say from
the Treasury Department.
Puri, another state bank, and they posted him here on 6/10/99.
No, but where are the vacancies now?
Vacancies is, my lord, so these 2 posts after their death, we too continued. We were continuing as sweepers. We assumed charge and continued. They say that we are continuing on the...
We'll ask them. You are the employer. So you will be knowing who died, who retired. It's in your special knowledge.
In these 2 writ applications, which is before Your Lordship, nothing is there.
No, you tell us. We are asking you now.
Yes.
Now, because you in your reply you have said that 2 persons were.
But he is telling some new things with due respect. Let him say. He has right to say. But sir, all these things would not have to search the old writ applications and to find out actually whether the fact is correct or not.
No, in fact, there are materials on record.
Referring to the old record.
They are part of the record. Now, question is, For more than 2 decades, they have worked.
So their working is not that bank is exploiting their service. They are working with the order of the Honorable Court.
Where is the order?
99, sir.
That order it continue, but how long you will continue them in the same status?
So they have court side without.
May not be retrenched. Order we have seen today, sir. May not be retrenched. What kind of order? Order should be terse. Very
here, in
clear
fact,
cut mandate.
To explain your see, 2006, State Bank of India throughout India, they have made a policy decision and as per the Government of India's direction that to give it to outsourcing basis for proper maintenance, change of infrastructure and all that. All the banks of Odisha, they adopted in 2016. 2016 onwards, no fresh recruitment. It's all outsourcing for maintenance of the building and other things.
That question will not arise in their case because there is a direction to continue them in silence.
Exactly, I'm coming to that. Even if we have outsources and all work done by the outsourcing agency through their persons, they are still allowed to continue and pay the minimum wage. All minimum wages are paid, sir. Never it was defaulted. He said it is not paid and also not correct. I'll answer that in due course of time. And they were allowed to continue till your lordship delivered the judgment by the Honorable Single Judge when both 2012 and 2028 applications were taken up together. After finding was given, then we issued notice for termination and termination has been done. That has not been challenged before lordship. And they have been
When they were terminated?
They were terminated. Look, what is there?
They filed an IA seeking for a permission for retrenchment. That was not moved. That is why contempt is pending, the third contempt.
No, how can you terminate them without leave of the court?
Yes, that is they filed an IA for that.
You should, after the judgment was delivered, there it was held that they don't have a right to continue. They don't have a right to continue.
Where is the observation?
Trying to say that.
That is pursuant to impugned order only. No, that order is put in challenge before us now. That is his grievance.
That is the grievance. Only after that order it has been done.
That we do not.
So if the order goes, obviously that will be nullified.
That order goes now.
Right.
That order has to go because of Jago and Shripad.
Sir, there.
Five judgments.
All those judgments speak about substantive post.
No. That has done. That has gone. If, with due respect, because we have scanned all those 5 judgments, we have said in one judgment, if the sir which Panda has argued, where the services of a person are continued continuously for a long time with no complaint whatsoever, the contention that he is not working against a sanctioned post is not available to the state entity. And bank is a state entity. It is established under the State Bank of India Act.
So Jago says that.
Yes. That we have reprinted in our judgment. And one judgment is upheld by the Apex Court. SLP was filed, where we said long service will repel the contention that post is not available. Sanctioned post is not available.
Here, all those, he says that 2% died, I also said I'll answer.
The best way is instead of that, if instead of we passing some order, where because of Jago and other things, and they have suffered like anything, so many times they have appeared before the court. And we judges also have made very loose-end orders, maybe continued, maybe married, maybe children born. Like they are not the orders of the kind which we need. Orders should be written clear cut. They should have elements of mandate. That is not there. That be that as it may. Instead of we directing cost and other things which will be very heavy to the bank. Of course, bank matter will not rest here. We are aware of that. Therefore, we have to give very powerful reason to so that we have to minimize.
The bank doesn't have money; it's public money which is in the bank.
We do not agree with that. Therefore, instead of we passing some pungent order with a pen dipped in acid, you may advise your client as to what should be done in the matter, so that there is one famous shloka Perhaps you are aware of that. Vinashakale samutpanne ardham tejita panditaha. Yes, ha. It's very subhashita. Maybe. Therefore, you advise your client. We are calling this matter tomorrow. You advise your client. These are two persons who have been put to trouble. This is not the way that the Article 12 entity should treat the citizen. Scheduled caste they are. Number one. Number two, since 1994, petitioner number one. Since 1995, petitioner number two. They have been hovering in the court for years with all these cases. That should not happen. Therefore,
sir, in fact, if your lordship looks at the background, I'll definitely talk to the, as your lordship suggested, and I'll try to resolve the matter as your lordship suggested.
That's all.
But in fact, what has happened, so there are a number of candidates who were appointed as either temporary or NMR or workshops or daily wages. So there was a discussion with the Federation, Workmen Federation and the bank. There were about 5 settlements. All settlements they have categorized which are the person to be regularized. That was done in way back in 1995, 96 and 97. So these 2 persons, they are daily wages. They themselves filed rate applications, they are daily wages. They were never temporary. As he says, we have been accepted. I'll explain that that's not correct. That's a different aspect altogether. Those persons, after the settlement was over, they prepared a list.
In that list, they did not figure.
No, they don't figure.
But that what they should do.
No.
Now you have seen
they didn't figure because it's a long pending prior to 88, 89, all those persons. So that has been closed in 97. They were not in the list. Those persons who were left out, they filed writ applications. That was dismissed by the Hon'Ble Court. They challenged the matter before the Supreme Court. That was confirmed. Another batch of persons filed another writ application. They withdrew. And some of them went to the Tribunal, Industrial Tribunal. Tribunal actually, some matters is still pending. Let me clarify. And some matters, court has directed you regularize if a person was engaged in a substantive post. And one of such cases, there a lift operator. He was in a vacant post, he was adjusted. These 2 persons were fired 2099,
94, 95.
95. Those cases have been disposed of as your lordship, those the order has been passed. Then 2012, they filed another writ application. 2020, they filed another writ application.
Because they are not being treated.
So those writ applications have been considered.
How many times they should come to the court? Scheduled caste members. You are not that you are appointing them as lieutenant governors.
So
you are going to appoint them as sweepers.
Right.
And howsoever advanced your bank may be, sweeping has to take
But
place.
in fact, they are not discharging their duty. They have been paid salary because work has been done with outsourcing.
We do not know.
No fresh appointment has
No,
been made.
this order appears to be wrong order. With the due respect to the learned single judge. Since we are sitting in appeal, we have to say this. Otherwise, we cannot set aside the order.
They give you some time to discuss with the officers.
What proposal you will carry to your clients? Because we are going to, the appears to be that
So
way.
whatever your lordship said, I'll just
No,
say.
but what we say is, see, you are a man of high standing. We are not just praising you.
No.
We are saying it from the heart. Okay? And you are not the mouthpiece of your client. You are an officer of the court.
Exactly.
And you are higher officer of the court because you are wearing silk. More responsibility.
With responsibility.
Therefore, you have to do justice. You should tell them. Otherwise, we pass the order. That's another thing. You are entitled to put forth your contention. He has almost put forth his contention.
Give me a week's time, in fact.
1 week. We should not forget all these.
Well, yes, that is.
So yours have already noted.
Of course, we have noted is also true.
Vacation will be approaching, my lord.
Before vacation.
That is
Vacation we are completing.
We are suggesting something from our side.
From our side.
18th, your lordship will call this matter. Because I have tried to resolve it as your lordship suggested.
Do something. 18th. How many cases are posted? 16. less than that, before that.
Say 18th, 2 o'clock if you're say fixed.
18th, 2 o'clock.
Yeah, that's better.
Yes. Heard learned counsel for the petitioner and learned senior advocate, Mr. Mishra, appearing for the management. A plethora of litigations are noticed from the record. First one. We have noted the march of law of regularization from Dharwad daily wages case to Shripad.
I have given the judgment today also. That judgment also I have given.
First off, there appears to be a prima facie case for granting relief to the appellants herein, who admittedly have put in service as sweepers. First petitioner from 1994 and the second from 1995. First, the law, as it now stands in the June of its life, tilts in favor of the appellants herein, in as much as arguably the impugned order of the learned single judge has missed the march. First off. Next paragraph. At this stage, we suggested to both the sides to negotiate a settlement with fair degree of with fairness and justice. First off, learned Mr. Mishra, in his usual style, agrees with this proposal and wants to confer with his clients. First, to facilitate the same, a short accommodation as of necessity needs to be extended. First time. Next, in the above circumstances, call this matter for further hearing at 2 p.m. on 18 instant. And we have made this order so that it can sit under the shadow of this order and negotiate the settlement. Otherwise, you are because he is a statutory body, you are claim. They may say, no, we are not agreeable, this, that, etc.
No, absolutely.
Okay. And put those notes also in our note sheet.
Pardon.
Yes, sir.
I know 25. Today also I failed to catch the flight test. Last week it was 35 and my matter will be concluded 34. So I pray matter will come up tomorrow.
Tomorrow? You should show mercy to the judges also. You judges should not run away from this court.
I'm sorry, that part I couldn't realize. Tomorrow.
What is the urgency? What is that matter?
Considering the urgency, my lord, were pleased to direct the matter to be listed immediately after submission. That's on 22nd February.
What is the matter about?
Well, that is the 150 crores property. The developer has failed to respond for last 10 years, and the property, after completion of investment of 40 crores rupees, is lying idle, and the landowner cannot proceed further. And it's a government leasehold land. The siege now facing the vulnerability of
tomorrow. And day after, use that.
May I pray the meeting come under order?
It's on 18.
My lord, may I mention item 30?
Under orders.
Lordship, may I mention item 30 virtually?
Item 27. The matter of regularization, I made a mention, it has come covered by the judgment. I don't know. 20.
My lord, may I mention, Lordship?
Single